Mood music. Beautiful. Good morning. How you doing? Of the Governance in the Public Interest Task Force, which is a statutorily required task force that is formed to issue a report every 3 years. This is the second meeting of the current task force. Although not all of our members of the task force who will be participating are yet members, they become effective members as of January 1st of 2020. So Ruben Duran and Josh they are sitting in the back, or will be soon, to listen. Meanwhile, the active members of the committee or the task force are here with us now. The first, or the main purpose of this meeting is to finalize, hopefully, the area that we want this task force to focus on this coming year for its report, which is due in May, I believe, right? May 15th? Is that the due date? Something like that. Anyway, in the spring. And so we will be holding meetings and working on this between now and then, roughly 5 months or so. When we last had our meeting, we talked about what our topic would be that we would address this year. And just by way of background, the last two task force reports dealt very much with structural issues of the state bar. And that is, the first focused on whether the bar should separate into, which was then a unified bar, should separate into two distinct entities, which of course has happened. And the second produced what is known as the Appendix I to their report, which is in 2017, about how various sub-entities should be treated, which should go with the newly formed California Lawyers Association, which should stay with this organization, and so forth. And over the last several years, we have been in the process of implementing those recommendations. So now we're essentially through with that restructuring of the former Unified State Bar. The California Lawyers Association is up and running and doing very well in accomplishing its mission. We are very focused on our missions, which is public protection, access to justice, and inclusion and diversity. And so we now have the opportunity to think fresh on what we want to either look forward to or to look backwards towards and evaluate what we've done and see where we can strengthen what we are doing. So in essence, although at the last meeting we talked in terms of the topic for this committee, or this task force this year, being the status of the profession, I'm coming to you today with a slightly different focus, and that is I think there is an opportunity to do one of two general things, go in one of two more general directions. One is to look at the future of the profession. What are the impacts that are affecting the profession today, and what are the impacts that we expect will be affecting the profession into the future as far as we can see. That can involve a lot of different things. Or on another mode, should we look back and now that we have come through a very significant, obviously, phase in the unification of the former bar, should we take stock of where we are and how we might learn from those experiences and move forward. So those are kind of the two general ways that we may go. Dag, who is our liaison and the person who will be the staff person assigned to making sure that this moves forward and doing a lot of the work behind the scenes in between our meetings, was prepared to this morning to further the discussion that we had last time, which was on the future of the profession. So I put him in a somewhat difficult position of coming to you with part of what we want to talk about this morning, but not the whole thing. And I gave him 10 minutes to come up with the rest of the story, if you will. So I'm going to, at this point, turn it over to Dag or Leah, if you want to add anything, Leah, at this point. But that's the decision that I think we have to make today, and then further consider it.
Well, Alan, do you want to provide some context for why there's a decision to be made? I think there's some concern that there's a potential overlap between the future of the profession discussion and the work of ADLS, the ADLS task force. One, we don't want to duplicate efforts. Two, obviously there's a lot of interest in and perhaps concern about the State Bar's exploration of various ADLS-related issues, and so we want to be sensitive to that. So I think that has motivated a desire to perhaps have the task force reconsider a focus on the future of the profession. And so I want to be clear, that's why I think Alan has suggested that maybe we think about another focus for the task force. There's, of course, the possibility, as Alan mentioned, of having a very different orientation for this group, which would be documenting the reforms that we have already put in place. We are required to come up with recommendations as a task force, so we can't simply just document what was done. We'd have to review that and from there generate some recommendations. A third idea that I've had that we discussed a little bit is to talk about potential regulatory reform separate and distinct from the conversations going on in adults. And that would specifically be looking at this concept of risk-based regulation, where your regulatory system is not just receiving complaints and acting only on complaints, but using data and information to audit proactively in our world attorneys that might be at high risk or in high risk practice areas, to affirmatively go out and see and make sure that things are being done in accordance with the rules. So I think I wanted to give some context on why we're rethinking the focus of the task force and why it's a little bit messy, because this has happened in the last few minutes. So, so with that, I'd just like to hear some reactions maybe from the group, and then let's see where we're going to take this.
Just to follow up on that a little bit, and thank you, Leah, for that. We have heard over the last number of months, or we've received input over the last number of months from a number of our different stakeholders, that the push into trying to get ahead of the curve, if you will, on some of the issues that may be facing the legal profession or impacting the legal profession in the future, such as the impact of technology and possibly outside investment in law firms and so forth, was getting outside of people's comfort zone of moving forward. So I think that it is possible that we could look at some of the issues just to kind of get a better handle on some of them, but again, that may overlap with the ADLS committee. So the kind of middle ground, I think, between the two, and then as Leah has explained, is the regulatory approach to the approach to regulating attorneys, should I say. And that involves a more proactive audit type of a regulatory regime as opposed to a complaint-based. Right now, we discipline and regulate the profession by receiving complaints and then having our Office of Chief Trial Counsel, by and large, respond to those complaints and follow them through and so forth and so on. Other modes might be to identify higher risk practice areas, types of practice, not excluding anything, but just as examples, and affirmatively presenting options to those folks, education, whatever it is, wherever the kind of affirmative identification of potential problem areas may be. So that's that's another regulatory approach as opposed to the complaint-based. So that might be something that we could look at profitably. So we have, again, going back and kind of wrapping up, we have a statutory mandate to continually look at ways to increase public protection. We have a report that needs to be prepared, so we need to pick an area that we think would be useful and appropriate, and that would be well received. So, Dag, would you like to take it from there?
Well, I don't know that I'm going to take it from here, but let me add one thought to the conversation. If the concern is that we're getting out too far ahead, and that a more forward-looking approach to the work of this task force would be perhaps pushing beyond the comfort level of some of our stakeholders, I wonder if thinking of it not so much in terms of getting ahead, but rather catching up with with regulatory gaps that are appearing in the landscape. So if it were reframed in this way, Leah and I looked at a video, I don't know if you'd like to share the squabble video, but it's a fascinating little, I mean, within a minute you see this interesting sort of service being offered, which has attorneys in it. It fulfills a legal function, and yet there are all sorts of pieces of it that I think fall outside of the regulatory framework, and that could be useful for thinking about how this group would go forward to try to identify where there are other regulatory gaps.
So this is Helen Chen. I really like the idea of exploring proactive regulation. I think it dovetails well with the work that we did. Now I'm forgetting the year. Was it last year at our strategic planning session with a discussion about Colorado self-assessment program and the proactive regulation-based management that they have piloted. I think it's worth continuing that discussion. I think issues of risk prevention and loss prevention experiences that we have, certainly at my law firm and large law firms who have the benefit of working with carriers who have very sophisticated loss prevention materials, I think are things that we could explore, and I think dovetail well also with the sort of findings of the disparities report.
This is Debbie Manning. I agree. I think that we may be able to get ahead of some, some of the disparities, but also some of the practices that are having problems that are suffering. I think later on today we're going to discuss one of the reports that we had commissioned about discipline, and I think that that's being proactive in that space, in that sort of space of seeing what's going on, that we can document and have some metrics behind, and then sort of dig into why is that, and is there something that we can do to help with that. So I think that I like the idea of being more proactive and trying to help the profession in ways that it's not being helped now. What Dan was talking about, though, was interesting, where there may be gaps in regulatory functions with the legal profession. If there are gaps that perhaps we should, step into. I wouldn't know what they are off the top of my head, but to know that there may be some that we may want to get ahead of in terms of before they become metastasized and it's difficult to get ahead of them. So, no, I like that idea.
This is one. I'm just interested in understanding how we're going to move forward. But I appreciate the fact that we had a 45-minute discussion in September about this, but I'm interested in knowing what the moving forward, what the proposal is. I agree with Helen and Debbie. I think we look at the gaps like Dag mentioned. That would be interesting to pursue. I think we need to support, and where we can, the public interest as well. So take that in consideration. But I agree.
So I would say this is a bit really challenging for us. I think when this statute was put into place, my impression is that the bar did not have a very robust and meaningful strategic planning process, or a robust or meaningful strategic plan that it actually followed and implemented. And so I think this task force every 3 years was the vehicle for doing this sort of thinking that now occurs on a very regular basis by the board and is manifested in revisions to the strategic plan every year. And so I think what we're seeing here is, we continue to be required to do this, but we've got a lot of other things going on as a board and as an organization. And so it's trying to carve out that particular focus for this limited term activity that's going to be the value add and is not gonna sort of run afoul of all these other political sensitivities and other things going on. So that's the challenge. What I would say about the regulatory gap issue is that it is real. It's real. It's a huge topic. I like Jack's reframing of it. I continue to be concerned that we will ultimately run into the same kind of potential overlap with the work of adults, because what you see is the carve out, I think, of the practice of law. What is the practice of law happening really on the corporate law side, when you have like non-lawyers doing things that used to be done by lawyers. And that is a murky area, and part of that whole conversation that's happening over in the adults world. So I think it's very real and true. I would just be concerned that we would then be kind of coming against the same political challenges, frankly, that are happening on that side. So it's my 2 cents on that.
Yeah, I think there is that risk, but I would be comfortable moving forward as long as we keep our focus on trying to identify what the problems are and identifying what potential solutions are, without necessarily, I suppose we have to make recommendations. Yeah, that's the problem, statutorily.
Yeah.
Well, one can always recommend further study or the creation of task forces that would address the problem. So if the group ends up studying the problems and identifying the issues, then the recommendations may not necessarily be solutions to the problems, but rather the creation of other entities that would then resolve the problems.
Right, or further the investigation or whatever the recommendation is.
So I think one you asked a great question, was like, how are we gonna move forward? We do have to decide and settle on the focus for this group, and we can't really do both. For example, the both we're talking about right now would be proactive regulation, proactive risk-based or data-based regulation, or looking at the future of regulatory gaps. I like tax framing. They're two different things, and so I don't think we can do both of those by May, so we have to make a decision. Maybe we could talk a little bit through what both of those might look like. So on the first one, as we've said, right now we have a very traditional complaint-driven model. And there are other models, regulatory models, that are obviously you always are going to receive complaints. But will you also use the data that you have to go out and proactively audit and review what is going on? Not always with a disciplinary aim in mind, and it goes back to your point, Highland, that the intervention can be training and or self-assessment kind of requirements, not anything to do with the discipline system. So it can be a support model, not just a punitive model. But there are, the vast majority of attorneys we don't touch. We are providing this month and then going forward the recidivism data at the bar. And so when you take recidivism into account, it's a very small fraction of attorneys cycling through our system repeatedly, which is a problem, which means that we're not particularly effective. But there's a whole bunch of folks we're not seeing, and I don't think that means there are no issues. So looking at a proactive approach, it would be how do we use the data and information that we have, and certainly our enhanced access to data because of our new case management system, frankly. How do we use that to shape a new system that's not solely complaint driven? That would be option one. Option two is looking at the changes in the profession that have occurred so far. This, to my knowledge, is mostly happening in the corporate law, the business law market. We do have a white paper on this that was commissioned for adults, which really lays out very clearly what's going on in that space. There's lots of interesting things happening, and certainly we're not regulating any of it. So let's talk about regulatory gaps. They're huge. So that's option 2, is really to educate us on what's going on, and do we think there should be a regulatory role, or at the very least, should the bar have, as part of its understanding of its charge, a responsibility to be continuously educated about what is going on in the marketplace of law, because we aren't now. So I see those as the 2 different paths. We can't do both of them. In order to address Juan's point, we gotta decide and then work through it.
I'm not entirely clear on how addressing the regulatory gaps, I mean, how do we keep that separate from the work of adults?
Yeah.
That's my concern, is that it shades too closely to that work.
I don't know either. I mean, it's so important. It really is important, and certainly if I had my own, personal preference could win out, that's what we would look at, because I think we are so behind the ball as a regulator. But we don't understand the market. We're, but of course we have to be sensitive to a myriad of dynamics, and so I'm just not sure that we're going to do that if we follow that path.
And one thing, it looks like adults is already well down that road on studying a lot of that. And for us to come up with a report by May, I'm not sure how far we would even make a dent in understanding or what those sort of regulatory gaps are. So maybe they should still, do what it is they're doing. It seems like they're uncovering a lot of that kind of thing that, that we would be trying to look at. And so maybe the proactive regulatory is a way we can go. Maybe that's something we can get our arms around by a report today.
So are we settling on a focus area?
I'm not sure. Want anything else on your thoughts?
Yeah, I'm just thinking about the time frame and what we can do.
Yeah.
That's just, is it feasible, is it doable? I mean, what the recommendation is, I wouldn't know. I mean, I guess that we would take the lead from the state bar and staff and.
I think so, and I think several of you mentioned the disparities report that's on our agenda later today, and that really does dovetail, I think, nicely with this idea of focusing on proactive regulation, not necessarily from a disciplinary standpoint, but from a supportive or self-assessment standpoint. I think we need to do this work anyway. So having the task force spend some time focusing on what those approaches might be, I think would be useful, dovetails with something that we need to do anyway. We've got about 5 months, 6 months. The report is due May 15th. I think we can get it done. Our next meeting, we would come to you with some examples. There are other jurisdictions, none that I really know of in the U.S. other than self-assessment in Colorado, that or maybe Illinois also,
right.
But others in the UK, in Australia, where they are using data to inform their attorney regulatory strategies, and we could bring that forward for the next meeting so you can see some concrete examples of how it might look. All right.
I like that idea.
And when we talk about next meetings, in the past, the task force has met independently of the board meetings. And so I assume you're contemplating that we'll have meetings just of the task force, or are we always going to be tied, do you think, with the board meetings?
Well, we're trying to make good use of people's time, but I do think at this point, since it's taken us a while to coalesce around what we're gonna do. And we need to have at least, I think, a couple of meetings that are longer in duration. So I think there will need to be at least one meeting that's not necessarily tied to a board meeting, maybe the day before, the day after, give us more
Yeah,
time.
but we're already there now, I think. It's not having to be a separate day, next week.
Okay.
Do we have a commission?
I think I do, so let me just repeat back what I understand that I've been hearing, and then you can correct me if I don't have it right, and I can memorialize it. So we're going to be looking at proactive risk-based regulation, and I think that what staff are going to be coming back with will be looking at what is done in other jurisdictions. The UK, Colorado have been mentioned. We'll also sort of take a view of the landscape and find out where else we see proactive regulation, risk-based regulation taking place, and what we might learn from that. I think also what's been mentioned that would be useful to do is to really evaluate some of the categories in which we work, as well as the data where we have categories. So whether it's on the discipline side in terms of the study on disparities in the discipline system and how we might repurpose that data for looking at areas where attorneys are particularly at risk, whether it's the particular types of filings that OCTC puts in their notices of disciplinary charges, categories of those, or other data, the recidivism data, that also may help us point us to specific areas where we could engage in using data proactively to identify problems before they occur. So that's that's what I will summarize in my notes from the meeting and what staff will be working on.
I also wonder whether a useful point of data might be something that, and I don't know that we have time between now and May to gather it and crunch the numbers, but it strikes me that judicial councils and judges may have useful information about what are the ethical issues that they see arise quite often in their courtrooms. What are the challenges that they see attorneys have with respect to ethical issues, and are there proactive ways we could be addressing that through education or training or specific CLA requirements, suggesting that it's part of law school curriculum in terms of practical ethical training.
It seems to me we could at least inquire and see what's available, and if they have information that's useful that's readily available, you might be able to work it into the report.
Or we could even do a survey
A
through
survey,
the council.
yeah.
It's interesting because there's, I think, a very significant gap between the issues that they see and would share and that which they would ever report to us.
Right.
So,
Although we do have communication going out to the judges. OCTC is preparing to send out a letter that it sends every year to encourage judges to communicate with us and to share with us things that rise to the level of complaint. So I think that might be a vehicle that we would use then to try to engage more with the judges.
Yeah, but I think my sense is that there's situations in litigation where judges will impose sanctions, right, for a discovery abuse or something like that. That is arguably an ethical issue, right? But that doesn't result in a complaint to the state bar or state bar discipline. And yet, it's a real ethical issue that causes a lot of stress on the system. Undermines the integrity of the litigation process, and perhaps is something that judges would be willing to share if they understand that the state bar would be treating it not as a complaint that then triggers a disciplinary process, but really as information that helps us frame and shape our proactive measures, like education, for example.
And that's triggering another thought for me. Some of the other systems that I've looked at, one of the remedies or one of the tools in the regulator's toolkit is to impose sanctions or fines. So we don't have that now, but it's interesting because in a court context, a judge may feel like, well, I've imposed a sanction is the appropriate sort of what's the word I'm looking for? Result here, and so it's done. I impose a sanction. They screwed up. I impose a sanction. We're done. we don't have the ability to do that as a regulatory body, but other regulatory agencies do. And so that's something I think we could talk about as well. But I think, Doug, let's look into that letter. I think it goes only to presiding judges, I'm not sure. So let's look at it and see if it is a vehicle to at least raise that we're gonna be asking them for other information as well.
It's going out pretty soon, I believe. I've been talking with FCTC admin staff who need the mailing list.
Okay. All right,
Okay,
okay.
done.
Thank you. Sorry, you just got me.
Thanks for being here.
All right. All right, is there any other business for the committee? Anything else we would like to accomplish before we adjourn? All right, that takes care of the governance and the public interest task force meeting for this morning. And we can, I think, go on to the executive committee meeting shortly. So we will take a 5-minute break and then come back to the executive.
I'm not seeing the chair.
committee meeting. And we're going to
Duran,
Here.
LeBron, Manny,
Here.
Salih,
select.
I'm here.
Steinbrecher.
Here.
We have a quorum.
Thank you. I have no chair's report, so let us go to, and there's nothing on consent, so let us go to business. There's one item on business, 3A. The annual recommendation for appointment and reappointment of fee arbitrators and reappointment of presiding arbitrator and assistant presiding arbitrators. Mr. Andrew Tuft is going to present on this. Andrew.
Thank you. Thank you. Good morning. Can you hear me okay?
Yep.
Okay, great. Good morning, everybody. My name is Andrew Tuft. I'm the supervising attorney in the Office of Professional Competence. And in this role, I help to manage the State Bar's fee arbitration program. This is an annual appointments item, which seeks to reappoint our existing arbitrators, appoint new arbitrators, and appoint the presiding arbitrator and the assistant presiding arbitrator. As most of you are probably aware, pursuant to Business and Professions Code Section 6200 to 6206, California law entitles a client a right to arbitrate a dispute regarding an attorney's fees for legal services. Typically, fee arbitrations are handled by a local county bar association program where the services in dispute were substantially performed. However, there's a handful of situations in which the State Bar's program will step in to manage the fee arbitration hearing. And so this item is seeking to do three things, as I said: appoint one new arbitrator. And with respect to that, I just want to mention in January and February of this year, we had an influx of applications. And so in July, you may not recall, we appointed 9 arbitrators in July. And so although there's only one new arbitrator, I just don't want anyone to be alarmed. We actually have a total of 10 new arbitrators being appointed this year. And then the existing roster of arbitrators are checked to see if there's anyone's moved out of state, become inactive, deceased, or had public discipline, or has pending discipline. Those individuals are removed. And then lastly, we contacted the current presiding arbitrator and the 2 existing assistant presiding arbitrators. If they'd like to continue in their role, all 3 of them graciously accepted and have offered their services for the next year, and we're seeking to reappoint them in those roles. And unless anyone has any questions, I respectfully ask appointment of these individuals.
Are there any questions in the board members?
I will move the item for approval.
I'll second.
Okay, so Soleil moved and Manning seconded. Any further discussion? May I substitute the vote? The items. That concludes the business of the executive committee. We will reconvene with RAD at 10 minutes after 10.
Do you have a printed agenda, or should I use my screen? Morning. I'm going to call to order the meeting of the Regulation and Discipline Committee. My name is Ruben Duran. I am Vice Chair of the committee, sitting in for our fearless leader, Brandon Stallings, who is not with us due to a very joyous reason. He and his wife have welcomed their first child into the world, and so we wish Brandon and his family and their new baby every happiness and health. And we'll catch Brandon when he comes back next board meeting. Could I start with a roll call, please?
Tran?
Here.
De La Cruz?
Here.
LeBron? Manning?
Here.
Bertula?
Here.
Shaline? Salang?
Soleg. Here.
Soleg.
Soleg is here.
Soleg is right. Steinbrecher?
Here.
Duran? Duran?
Oh, here. Sorry. Duran is here as well.
Duran's here. Stallings?
First item on our agenda is consent, but there's nothing on that. We will go into closed session, but before I do, I wanted just to publicly acknowledge and thank Mr. Gary Shawns of Best and Krieger, who has served the State Bar in our community and our profession over the past year as the Rule 2201 administrator. Mr. Shawns will be leaving that role effective January 1, 2020, and so this is our public opportunity to thank him for the tremendous work he has done for the program and for the lawyers that we serve and the public that we serve. So Gary, thank you so much for all the work that you've done. Can we give Gary a hand? I'm assuming there's no public comment on closed session? If that's accurate, then we will convene into closed session. Thank you. Your patience, we are back in open session on the Regulation and Discipline Committee. We will move over to item Roman numeral 1, the chair's report. The first item is a call for public comment. Before I open it up to the room and to the telephone lines, I will note that the committee did receive one written comment on item 3E, which we will discuss briefly when we get to that item. Is there anyone here in the room who would like to offer public comment to the committee? Seeing none, I actually will also note for the record that in closed session, the committee heard a confidential report from the administrator, Mr. Shawns, but there's no reportable action from that item. Okay, is there anyone on the phone who would like to address the committee on public comment section? Hearing none, we will move over to item Roman numeral 2, the consent calendar. Committee members, does anybody wish to pull an item from the consent calendar? Seeing none, I'll entertain a motion to approve as presented.
So moved.
Somebody? Oh, second. Motion by Alan Steinbrecher, second by Sean Seleg. Is it okay to substitute the roll call? We all here? Okay, consent calendar is passed unanimously. We'll move on to the business calendar. Item 3A is a brief update on the annual hearings on State Bar disciplinary procedures, attorney competency, and admissions procedures, which are required under Business and Professions Code Section 6095A. It says here that Mr. Stallings will give that report, so that'll be me, and I will just note very briefly that these annual hearings are required by statute. Where's DAG? DAG has more information on this than I do. And they are scheduled this year for 2 dates, one in Southern California on Friday, the 22nd of November, which is, I guess, 2 Fridays hence, from 9 a.m. until 2 p.m. at the State Bar offices in Los Angeles. Those hearings are open to the public to observe and to offer comments on the disciplinary process and procedures. The second is here in San Francisco, scheduled for December 11th, same time, 9 a.m. to 2 p.m. We encourage anybody who's interested in seeing what's going on here at the bar with respect to discipline to attend any of those committees, and of course, board members likewise are highly encouraged to attend if they're available. Any questions on that? Yes?
Do you have people assigned? Do you have board members assigned to these yet?
We do not, to my knowledge. Lisa, do you know? Is that something that the chairs typically do?
No, I'm just curious.
Would you like to go? I can assign you.
We'll need one volunteer for each location, but we can manage that through an email solicitation process. We don't have to do it now.
Okay, great, thank you. Do I need a mic on? I've been talking entirely without a mic, I apologize. Okay, we'll move on to item B, the lawyer referral service proposed rules of procedure governing the review process for certification, revocation, and suspension decisions. This is a request to circulate for public comment, and we'll hear from Mr. Schapp, please.
Good morning. My name is Mark Schapp. I'm an Assistant General Counsel in the Office of General Counsel. This item seeks approval of a request to circulate for public comment new proposed rules addressing state bar court proceedings to review adverse decisions for denial of certification, revocation, or suspension of the certification of the lawyer referral service. By way of background, Business and Professions Code, Section 6155, authorizes and requires the state bar to promulgate a set of minimum standards and oversee the certification and the assurance of those minimum standards by lawyer referral services in California. Pursuant to those state bar rules, there is a provision that allows for an applicant or an existing lawyer referral service to seek review of any adverse decisions with regard to their certification. Those rules refer to state bar court rules of procedure. However, no such rules have actually been promulgated. This past year, the Board of Trustees approved a set of amendments to the lawyer referral service rules, including a proposal to move into the Executive Director's Office the review process. The Supreme Court, however, while approving most of the proposed amendments, directed State Bar instead to promulgate a set of rules of procedure and leave the review process with State Bar Court. And that's what these rules are intended to do. The proposal was prepared in consultation with staff of State Bar Court, the Office of Chief Trial Counsel, and the Office of Access and Inclusion, who are the primary stakeholders in this issue. I'm happy to answer any questions the committee may have.
Any questions for Mark? Okay, seeing no questions, I'll open the floor for a motion.
So moved.
Motion by Alan, is there a second? Second by Juan. Okay, substitute the roll call. All right, we're good. Thank you, Mr. Chef. Thank you. Item C, we're going to hear from Vanessa on the recruitment for the Special Deputy Trial Counsel Administrator. That's the Rule 2201 program.
Yes. Our current 2201 administrator, who is the person who oversees the cases that are sent outside the bar as a result of the Chief Trial Counsel recusing herself and other circumstances under Rule 2201 of the State Bar Rules. Our current administrator is Gary Shones, and he is retiring from the administrator position at the end of the year. He will continue as a SDTC, Special Deputy Trial Counsel, in some fashion thereafter, and he will help transition any new administrator. So toward that end, Ruben and I and Carissa Andreessen, who is our Assistant General Counsel in charge of the Rule 2201 program, will be tomorrow interviewing 3 candidates. And we hope that as a result of that, we will find a new one who can transition by 1/1/20.
Any questions for Vanessa? Okay, thank you, Vanessa. Item D, Donna, please, on voluntary resignation form revisions and request for approval.
Good morning.
Good morning.
Am I supposed to take this as a?
If you can use a mic.
Okay. Thank you, Donna Hershkowitz, Chief of Programs. I'm here to request a RAD and ultimately board approval for minor amendments to the voluntary resignation form that needs to be completed by attorneys who are seeking to voluntarily resign from the State Bar without charges pending. Currently, the voluntary resignation form requires attorneys who are seeking to resign to, under penalty of perjury, say that I currently have no clients, nor am I involved in any pending legal matters. I have no paperwork, files, or property to which clients are entitled, nor have I any client fees that are unearned and must be refunded. I will not practice law in California in the future without seeking or obtaining readmission. A problem that's been brought to our attention by some attorneys who are as ethical as we would want them to be is that they feel they cannot sign this form under penalty of perjury if they are barred in another state and are simply seeking to voluntarily resign from the California bar. So they may be barred in New York or Oregon. They cannot say under penalty of perjury, I currently have no clients, nor am involved in pending legal matters. Maybe they are even practicing law in California, but as a member of the U.S. Trade and Patent Bar, where they don't need a California licensure to do that, so they will continue to practice law in California, again, feeling ethically challenged to sign this form. So we're proposing here, and this is these revisions were worked out with a combination of representatives from the Office of General Counsel, the Office of Attorney Regulation and Consumer Resources, State Bar Court, as well as our Office of Professional Competence. Sought the input of our liaison to the Supreme Court, and with all of those parties agreed that these changes to the form were appropriate to really deal with the situations that we intend the form to deal with, and not hamstring folks who are barred in another state who are trying to ethically present information to the bar and are seeking to voluntarily resign.
Thank you, Donna. Any questions for Donna from the committee? Go ahead, Sean.
Thank you, Donna. So these changes all look good to me. I had a question. This may be more for Melanie, who I see in the audience. That one of the representations the lawyer has to make is that he or she has no paperwork, files, or property to which clients are entitled. So I would think often lawyers would still possess client files, but the intention of this is that the trigger under what used to be Rule 3700 isn't currently in effect. Is that right? And they wouldn't have to. Do people have to shed all their client files? And if so, what would they do with them?
I do think that that's the expectation.
Melanie, would you mind coming forward and using the mic so we get you on the record? Thank you.
I do think that that's the expectation, that if they were actually resigning and presumably had files for California clients, that they would be in fact returning the clients to the files to the clients to the extent they could.
They would give them back. I guess that in part because the court wouldn't have any jurisdiction over them anymore once they resign. Okay. Thank you.
And the language of the form does reference to which the clients are entitled.
Thank you. Josh?
The changes seem all necessary and important and part of continuous improvement. I guess I'm just curious how long we used the other form and how many people raised this, and whether or not it was just an individual that was uncomfortable signing it, or whether there was a dispute that arose because of it.
So we've gotten, through our Office of Attorney Regulation and Consumer Resources, we've gotten questions about this form from a handful of attorneys, not an overwhelming number, but a handful of attorneys who have said that they felt uncomfortable signing it as is. And so we're not going to sign it because they did not feel like they could do so. And so this is, as you said, sort of continuous improvement, recognizing that the points that were made to us appeared entirely valid, and we wanted to make sure to make those corrections to the form.
Thank you, Don. Anyone else? Okay, do we have a motion? We don't. Would you like to make one?
I move approval of the item.
Second.
Motion by Sean, second by Josh. No objection, we'll substitute the roll. Great, thank you, Don. Okay, moving on. Item E, is proposed additions to the board policy regarding consumer alerts. And we'll hear from Suzanne Grant on that, please. And just as a reminder, this is the item to which we received written public comment, and I think Suzanne will describe it so that we're clear on what it is, or would you like me to do that, Suzanne?
Did everyone receive a copy of the public comment, or?
Yeah, is your mic on?
Yeah, I can address the substance of it when I talk about the item,
Okay.
if that's all right, as long as everyone has read it.
Sure, and just before you start, I will just say for the record that we received an email dated today's date from an attorney named Megan Zavia, is the way I'll pronounce it. It's kind of extensive, so I won't read it into the record, but Suzanne will discuss generally what it says.
Okay. So my name is Suzanne Grant. I'm an Assistant General Counsel in the Office of General Counsel. First, I will just summarize this proposal, and then I will briefly address the public comment. This proposal is for two additions to the board policy on consumer alerts. The board approved the policy in November of 2018. The policy was quite extensive regarding what information was going to be added to the attorney's public profile for various situations. The amendments only involve situations for when an attorney is not eligible to practice law. In the original policy, there was a number of specific either involuntary administrative inactive enrollments or disciplinary inactive enrollments, which would be suspensions by the Supreme Court, that the consumer alert box was to be put on the website pursuant to the policy. However, left out of the policy were two categories of one of involuntary inactive enrollment, and that's for the noncompliance with the fingerprinting requirement as of December 1st, 2019, which is in a few weeks. There are a number of attorneys that will be involuntarily and actively enrolled for failure to comply with that requirement. So this amendment proposes adding that as one of the bases to have a consumer alert box alerting the public the attorney is not eligible to practice law. The other addition is for attorneys who are suspended for non-payment of licensing fees. While the original policy did specify that there are consumer alert boxes for attorneys that resign with charges pending or is suspended or disbarred by the Supreme Court, arguably suspension for non-payment of licensing fees would fall under that, but it's not very clear from the policy whether that applies to only disciplinary suspensions or not. So this would clarify that the consumer alert box would be placed for attorneys who are suspended for non-payment of licensing fees as well. The reason these are being added is that they are consistent with the other categories of consumer alert boxes, and if we did not include them, it would create an inconsistency. So that is essentially the two additions that we are asking the board to approve. And I just want to briefly address the public comment. The public comment was unhappy with the policy in general. They raised the fact that it did not support of the public protection mission to have consumer alert boxes for administrative issues such as MCLE noncompliance. However, the board has already approved that as part of the policy from November 2018. These are just additions that are similar to what the board has already approved. And the comment also noted that we are not putting this out for public comment. We had put out the original policy for public comment. The reason we are not doing that now is because public comment is not required if there's not a rule being proposed either by the State Bar or proposed to the California Supreme Court, as well as the fact that we are aiming to do this so that we include those attorneys who are being involuntarily and actively enrolled on December 1st. So there was a timing issue where we wanted to get this before RAD and the board as soon as possible. So that is essentially it. If you have other questions that you want to address based on that public comment, I'd be happy to answer them for you. Yes?
So I just want to clarify the consumer alert that is described in your memo would only be on the website during that time when the lawyer is ineligible to practice law, right?
Correct, yes.
And I just want to refresh the committee because one of the lines we sort of drew in formulating when a consumer alert would go up versus some less prominent disclosure of an action against a lawyer, such as not completing your MCLE, was that any time the lawyer is ineligible to practice, that's something that the public should be alerted to. So this would only apply when an actual suspension is going into place. It wouldn't apply the day after a lawyer has failed to comply with MCLE. It would take more time than that, and it's fully within the lawyer's power to remove the suspension, to remove the consumer alert for an MCLE failure by completing the MCLE, if I understand that correctly.
Yes, that's correct. So it's only there when the attorney has actually been placed on inactive status or was officially, or the suspension or disbarment took place.
Okay, so, right, so the purpose of the alert one purpose is to make sure people understand that this lawyer cannot represent them lawfully. And with regard to the fingerprinting, my reaction to the public comment was, a lawyer who has refused to be fingerprinted, that is extremely troubling as to why the lawyer would not comply with that. So that is not, there's no equivalence between that and MCLE failure. But, so with that, I would say I support this. And in terms of the lack of a public comment period, if members of the public have further comments, they are welcome to submit them to the bar and they would be considered. But I think public comment is not required for this item, and there is a timeliness issue that needs to be implemented, so I support the proposal.
Can I just ask a clarifying question? So our current policy addresses all other forms of administrative suspension. So failure to pay child support, so we've addressed all administrative suspensions, and now we're bringing these two in.
That's correct. And right now there's only going to be one category of attorneys who are inactive for some reason that's not going to be addressed. Well, obviously voluntarily inactive is not addressed, but and those are attorneys who are inactive due to some sort of substance abuse or mental incompetence proceeding. So there's still that category of individuals who we're not going to have the consumer alert box for, but every other category of involuntary inactive enrollment or suspension should now be included in this policy.
Josh?
Couple issues I'm trying to understand. So generally, I like to err on the side of public comment when possible. I see that this is, we believe, staff believes based on categories that the board approved previously that that's not necessary. So two questions. What are the categories that this would fall under? And is it administrative categories? Is it that broad? And then a follow-up question. What will the consumer alert say? Is it going to be specific to it's a fingerprinting issue, or is it, I don't remember from November if those were, how much specificity goes into that consumer alert box?
Dina can answer the question about the specificity of the alert, but I believe they're all the same, and then I can answer your question about the categories of involuntary active enrollment. I don't know if this is on. Oh, it is on?
Is it? I'm not sure. It's not specific. The consumer alert is specific only to the extent that it says whether an attorney's been suspended or whether they've been enrolled as inactive, but it doesn't list the underlying reason. Later in the web page, you can see the underlying reasons for the actions, but the box is more brief.
So an individual that was suspended for maybe more egregious acts versus non-payment would just say suspended in the box.
It's a little bit of a paragraph that talks about being suspended.
To the agenda. It's page 17. I think if this is the one where it's for administrative suspensions. It says the state bar has placed this attorney on involuntary inactive status as a result ineligible to practice law. We post consumer alerts online in most instances when attorneys are placed on involuntary inactive status.
But they're all just that broad, I guess is what I'm asking.
Except for a felony charge. I'm looking in here, I see for the felony charge, they're not all the same. Depends.
There's a disbarment one as well, for example, that says disbarred. The specificity of the suspensions, in the case of suspensions, later on the web page where it talks about specific actions and effective dates, it goes into detail whether it's disciplinary suspension or administrative suspension, and at least specific to what type of administrative suspension, for example. But the box itself is a little bit more generic, and it's more to catch the eye of the consumer to make sure they understand that this attorney is not eligible to practice.
Okay, but the consumer would be able to see the details of that suspension or inactivity.
That's right.
Thank you.
To address your question about the other categories of involuntary inactive enrollment for administrative reasons, there's three of them. One is the attorney is delinquent in child support obligations. The next is that the attorney has failed to comply with MCLE obligations. And the other one is that the attorney has failed to pay a mandatory fee arbitration award.
So I'm not, maybe I didn't ask the question artfully. I understand that those three are ones that we, as a board, acted on, but it seemed like there's a broader category that you thought these fell into. Because we didn't specifically put these out for public comment. Was it more that you felt that these were just administrative in nature and the other ones were also, and that made it?
Yeah, so these are involuntary inactive enrollments that the state bar is authorized to do on its own without going to the court. So the two that we are the one that we're recommending, the fingerprint date, as well as the non-payment licensing fees, they're similar in nature in that they're more administrative. So they're similar to the ones the board has already approved. So and non-payment licensing fees is a suspension, but it's obviously not non-disciplinary. I should use that is a better word. They're both non-disciplinary actions.
Okay, thank you.
Alan?
Alan Steinbrecher. Suzanne, would you either explain briefly or turn the mic over to somebody who may know the answer to this question, and that is, what is our procedure for removing the names once the attorney has complied? Once removing the notice, once the attorney has complied. And the reason, obviously, for my question is I want to make sure that we have an efficient system for removing those boxes once the attorney's back in compliance and it doesn't linger for a matter of days or weeks or whatever until it's addressed.
Well, I will point out that the policy the board approved in November of 2018 did specify that consumer alerts would only remain until such time as the attorney is reinstated to practice. I don't know if you can speak to the particulars of how that happens.
Specific to the administrative actions, which my office is responsible for, because there is generally a high volume of those, we insisted that the process be automated, and so it's linked very directly to the action in the record. And so when that action is ended in the record, it automatically brings down the consumer alert. So it is automated and it's immediate as soon as the action has been resolved and they're in compliance. My understanding with some of the discipline records, it's a little bit more manual for those consumer alerts, and they're being handled by the Office of the Chief Trial Counsel. But the intent is that it's immediate as well, but I think there's a little bit more of a manual process in those cases.
So 2 questions. Number 1, on the automatic removal, how quickly does that trigger occur? In other words, something happens that automatically removes the box, but how long does that triggering process take? And then second, perhaps Melanie or somebody can explain what OCTC does in the other set of cases.
For the administrative actions, it's immediate. It's within seconds or moments. We've tested it so that when we end it, it actually removes it from the record. Within minutes, it will be off the website.
I may be struggling a little bit with my question because I don't understand exactly how this works, but I understand that as soon as the action is taken, it automatically removes the box. But
how long does it take to take the
however
action?
you describe it, how long does it take for the action to be taken?
So when someone is out for MC lien non-compliance, for example, and they need to prove that they brought themselves into compliance, they file a packet with us that we have to review and make sure that they're now in compliance, that they've made up all the requirements, they've proved it, they've made any penalties, so they've paid for any penalties and everything's resolved. Once we've determined that, we, in the system, end the action and change your status back to active. So that's something we've always done. Now, that is automatically linked to the consumer alert, so that the consumer alert that was there will automatically get removed at the same time that we do that.
And how long does the process take from the time you receive the information in whatever form that the attorney has now complied until you are able to input it into the system?
I think that we handle them as promptly as we can because we know it's going to affect their status. I think our turnaround is about 2 business days right now. So to take the time to review the material and determine that it's complete and either reinstate them or alert them to any deficiencies.
Thank you. You answered that part of my question.
Let's speak to that.
Good morning. As Dina mentioned, that's how the administrative ones are handled, and they are in some ways much easier because they are data entries into the AS400 mainframe system that we use, and there is a link between that system and the system that posts the consumer alerts on the website. And so that's what Dina was talking about. The discipline-related ones are a little bit more complex because we've had trouble locating or tying individual actions in our new case management system to the posting of consumer alerts or the removal of consumer alerts. As some of you may have noticed, there are some consumer alerts that this board authorized posting in November of 2018 that we still are not posting at this point. And the reason for that is that we were very cautious about implementing that policy without some sort of automated system so that we could minimize and potentially eliminate either erroneous posting or essentially the failure to remove promptly a consumer alert that should be removed. We didn't want that situation to occur, and we didn't want a situation to occur where we posted it in error initially. And so we've been working with IT to develop a similar sort of automated system that Dina has on the administrative side, on the discipline side. That is not quite in place yet, so we have continued to only post at this point the 4 alerts that we were posting before this board took action in November of 2018. And we will hopefully be able to roll out something, whether it be fully automated or partially automated, sometime early next year. Part of the issue is that there is, one of the alerts, for example, is the filing of an NDC for alleging, quote, major misappropriation, which is sort of a term of art, of $25,000 or more of client funds. And so that will automatically require some input on the part of the attorney who's making a judgment call about what that notice of disciplinary charges contains. Because it's not a particular charge or allegation that says that it is $25,000 or more of client funds. So in order to effectuate that policy, it will require some discretion.
Thank you.
Thanks, Steve. Thank you, Alan. Any other questions from the board, from the committee, rather? Okay, seeing none, there's a resolution before us. Can I have this motion?
Motion to approve.
Moved by Juan de la Cruz, and second. Mr. Soleil. Any objection to substituting the roll call? Seeing none, the item passes. Item F is a review of metrics for offices within the Regulation and Discipline Committee purview and Discipline System Statistical Report by Lisa Chavez.
Hi, good morning, everyone. My name is Lisa Chavez, and I'm the Director of the Office of Research and Institutional Accountability, and I am also the new RAD Committee Coordinator, so I look forward to working with all of you today and in the future. I'm here to report out on this agenda item, in particular with regards to the metrics that are under RAD's purview. We received the report, and in that report, we focused on describing the metrics that did not meet their targets. In the interest of time, I'll just focus on a few. The first one, of course, is one that's great interest to everyone, which is the maintain annual caseload clearance rate of 1.0 or higher. The February go live of the Odyssey case management system is still having an impact on this metric, as this metric is a 12-month rolling average. But we're feeling really good that that efficiency continues to improve because users are becoming more familiar with the system. And this improvement can be seen in OCTC metric number 6, where the overall inventory has dropped for the first time since go live. Also, with the recent fee bill that was passed, we anticipate having additional staff resources which will assist with case processing times and this metric. Another metric I'd like to point out is with regards to Office of Probation. Unfortunately, none of the metrics related to probation, the Office of Probation, are available for your review this time around because due to challenges of retrieval of data within Odyssey, staff continues to work on this issue, and we expect these metrics at your next Board of Trustees meeting. Unless you have any other questions, we can perhaps move on to my discussion of the report. Should I do them all? Yeah. All All right, so now I'd like to describe a new report that my office is going to be producing and sharing with you. We call it the Discipline System Statistical Report. We'll be sharing this report with you on a monthly basis starting this month. And we'll be sending it out to you via the board blast. So what this report is going to do is going to compile all the discipline-related metrics that are part of the broader set of metrics, and then produce them for as much data as possible for over a 12-month period. Right now, when you see the metrics report and the metrics that are for discipline-related, they often have, say, up to 6 months worth of data. So moving forward, a monthly report will be produced where you'll have all 12 months of data for all metrics that are under the discipline system's purview, as well as additional measures of the discipline system that are not, for a variety of reasons, metrics. Examples of those types of additional analyses includes data on recidivism rates. We also have very interesting survey data for complaining witnesses on their perceptions of access and fairness of the discipline system. And we also will share out information on OCTC's total inventory, disaggregated by stage, for example. So we have a nice chart on total case inventory that's at the intake stage versus the investigative stage, pre-filing stage, post-filing stage. So again, this is going to be a report we're going to be producing on a monthly basis, and we'll be sharing it with you all via PDF format, via a board blast.
And I'm sorry, we had some miscommunication. We are going to need to and should be providing those publicly, so we can send them on a monthly basis via the board blast, but then for the board meetings, post them to the RAD agenda. They can substitute for the current metrics item. And because it does have the really important data that I think RAD needs to be talking about, which is recidivism and procedural fairness, I think probably our most important metrics, and we want to start talking about them at this level as well. So we had miscommunication. I thought this particular report was going to be posted for today's meeting. You'll get it in the board blast, and then we will post the 2 months for the next RAD meeting that will take place in January.
And of course, if anybody from the public wants to see a copy of that in advance, they can make a request, either public records request or just call the state bar offices, I'm sure.
Absolutely.
Great. Go ahead, Jim.
So I just have a question about the ethics hotline metric. I see that you're going to reevaluate it, but I don't, actually I don't understand the rationale behind a desired ratio of new callers to returning callers. And it seems to me something more useful would be a survey that callers to the hotline complete either, there's a lot of companies have these automated surveys now, or by email or whatever, where they're asked, was your issue resolved? Did you get the information you needed? That would be a much more useful metric. And maybe another question might be, would you call the ethics hotline again? It's another way of measuring satisfaction. So I'll just throw that out for your consideration.
And they are looking into that, because I compiled these measures and I talked with Randy, and the Office of Professional Competence, and our call center currently has that post-call survey, and the Office of Professional Competence is looking at adding something like that. And so I will mention those 2 questions. I think that one of them was already considered, but the use it again question I will follow up.
That would be useful, and then also to, especially if there's a negative answer, to have a free-form response, so that if there's an issue, then Randy and his staff can make changes as necessary to address it.
So if I
I
can
think
just,
Donna wants to add something.
yeah, if I can just clarify. So the ethics hotline recently, very recently changed from what was referred to as an outbound call center to an inbound call center, where we're getting the calls in. And so we are launching this month. We're doing a soft launch this month of that customer satisfaction survey at the end of the calls, with the hard launch, I think on December 1st. So we will be asking those customer satisfaction questions, and you're absolutely right. I think we had traditionally asked that, looked at the new callers, previous callers as a proxy for customer satisfaction, because we do have people who have been very satisfied with the service that they've gotten and the answers that they've gotten, and so they are repeat callers. They call back, they know that's a good way to get answers. I think that really has served as a proxy when we had the old system. Now that we are launching the new customer satisfaction service as part of the inbound call center, replacing that metric makes a ton of sense.
Thank you, Don. Any other questions for Lisa? Okay, I think this is just a receive and file. There's no need for committee action. Is that correct? All right. Are we done? Yeah, nothing further on the agenda. I will adjourn this meeting of the RAD committee, 11:18. We're booking.
In 15 minutes?
Yeah.
Diversity Summit, which only a couple of you have, you haven't had the benefit of actually seeing our data. So they're going to go through some of the attorney census data with you, and we're obviously using this as the basis of a lot of our inclusion and diversity work. So take it away, ladies.
Hi, it's still morning.
I think because it's Chris, we're lunch, we're not in a meeting. Why don't you feel free to come up?
Yeah, anywhere.
Yeah, our
Anywhere that's not spoken.
new board member, Chris Iglesias, welcome.
Okay, terrific. Okay, I'm going to say good morning again because it's still morning. My name is Lisa Chavez, and I'm the Director of the Office of Research and Institutional Accountability. I'm here with Carolina Almarante, and we're going to discuss the California Attorney Census. Okay, so what is this? Okay. Ultimately, this is a voluntary survey that we administer through the My State Bar profile, and all active licensed attorneys are asked to fill out a survey on a completely voluntary basis and give us 3 buckets of information. First, we ask for demographic information, race, ethnicity, gender, sexual orientation, and disability status. We ask for information about their current employment status, and in particular, we ask which sector you work in, which subsector that is, and we ask questions about where they rank within their organizations. And then finally, we ask a series of questions with regards to career and workplace satisfaction, and this is really getting to issues of like diversity and inclusion within the workplace. So why did we do this? Well, August 2018, we had our first diversity summit, and that really informed the State Bar's diversity inclusion efforts. And participants at that summit highly recommended that the State Bar lead data collection efforts on diversity in the legal profession throughout the state. And in September of that year, AB 3249 was passed that expands the Bar's statutory mission and to include issues of access and inclusion. And in March 2019, the strategic plan was updated with Goal 4, Objective K, and in particular, the language reads, to collect demographic data about licensed attorneys through all stages of their career. And so what's neat about this particular survey is that because it's tied to it's not an anonymous survey. People log in to pay their fee bills and then to pay their fees, and then there's their My State Bar profile, and they click this voluntary survey. If people, we envision people doing this every year. They can always update their data that they're submitting to us. And, you know, we will, in the end, 5, 10, 15 years out, we will have a nice set of longitudinal data where we will be able to do some very interesting analyses on exactly this, analyzing how people progress throughout their career. So let me tell you a little bit about how our first rollout went for the 2019 California Attorney Census. So we rolled it out January 2019, so earlier this year. At the time, and this year we had about 190,000 active attorneys. From what we can, so again, this is, they log in, they fill out their fees, and then there's a portion where they say, fill out this survey. About 125,000 people actually logged into that part and viewed the census. And around 93,000, around 74% of the 125,000, reported on race, ethnicity, gender, and their employment sector data. And among that universe of people, 93,000, we extracted all of their data and analyzed and use that as kind of our universe of people for which we conducted a series of analyses that we'll be sharing with you. So what are we doing with this data? So first, we are, and Carolina's handing out, and I'm sorry we didn't hand it out sooner. We're writing some really short, what we're calling bar briefs. I'm uploading this to their website, and we have a list of topics that we're slowly going to be going through. The first, we've already published 2 of them, and number 3 is in the works right now. So the first bar brief is on diversity inclusion in the California legal profession. So it's really at a 10,000-foot level. Like, we have all these people who filled out the survey. Let's talk about how diverse the population is on these demographic factors and how this has changed over time. And the second bar brief described the multiracial population within this within our population of attorneys. So that's that, and like I said, our bar brief 3 is now currently in design, and that one will focus on employment sector. Second, we've done a series of diversity analyses where we really examine diversity by sector, by subsector, and examine all the career satisfaction questions. We do this by race, ethnicity, and gender, and those are the 2 demographic factors we focus on so far. Like I said, we've done a series of analyses, and we've been able to share these data via presentations with several audiences. We've shared this with COAF. We shared this at our most recent Diversity Summit. We shared it with the Legislative Hearing on Diversity, the California Minority Council Program, and California Change Lawyers. So we either presented data to them, or we actually gave them some of our slides for them to make, for our partners in these various organizations to make use of. And then finally, our goal is to compile our most interesting analyses into the first annual diversity report of the state of the legal profession, and we'll be publishing that report next month in January, 2 months from now, January 2020. So, am I turning over to you now? Yeah, okay. So now I'm going to turn this over to Carolina Almarante, who's the lead researcher on this project, and she's going to share some examples of the analyses we've done so far.
Thank you. So the current charts really provide a snapshot reflecting attorneys that are licensed California compared to the California adult population. And some key things that stand out when we were looking at this comparison is that we find that for the most part the attorney population is male and white. And for specifically looking at Latinos, there's a underrepresentation of Latinos in the California licensee population. So these are the type of analysis that you will be seeing us highlight in the presentation, is the comparison across either race, ethnicity, and then looking at employment. This specific chart provides the perspective a little bit differently, where we're looking at attorneys that are admitted into the bar over the past few decades. And what is interesting about this chart is that you see over time, the entry of the Asian cohort is much higher than other racial ethnic groups. There's a other category here. These are attorneys identified with more than one race, and this group is also increasing in their admission to the bar. Latinos are third, and then on the bottom portion, you see that the entry of black attorneys into the bar remains steady. Sure. That's other includes Latino and black. So those who selected Latino only selected Latino. That's correct. Yeah. So this graph looks at several things. So what we're trying to understand is within each racial ethnic group, as well as gender, where do attorneys work? So in its totality, majority of attorneys work in the private sector. When you look at racial ethnic group, you see that narrative continue. However, you do see that for black attorneys, there is a small proportion that's higher in the public sector. And then when you look at gender, similar breakout where majority are in the private sector, with females having a slight percentage higher in the public sector. So again, this is just trying to understand where are attorneys working in given their demographic group. And so what we're doing now is that we're digging deeper into the sectors, and we'll highlight the private sector for the purpose of this presentation, but we can do that for public, nonprofit, and other categories that were listed, which includes academia. So this is a parity analysis. What we're trying to understand is what is the composition of total attorneys in comparison to attorneys that are in the private sector, in the public sector, in a nonprofit, and other, when looking at the racial ethnic composition of those different sectors. And so the narrative continues where a majority are white attorneys working across the different sectors, with the exception that for those that in nonprofit, there is a higher proportion of Asian attorneys, as well as Latino attorneys, and those who categorize themselves as other. Oh, go back. All right, we skipped them, sorry about that. So digging further into the private sector, so again, the parity analysis is looking at attorneys in the private sector solely. And in those attorneys who said, I work in a law firm, those who say I was a solo practitioner or I am a solo practitioner, and those who identify as being a corporate in-house. And also looking at the composition of each sector by the racial ethnic group. You see a similar narrative where majority are white, with the exception that corporate in-house has a higher percentage of Asian attorneys employed. So again, this analysis helps to understand where are attorneys across these different sectors, and just a comparison point within those sectors and those subsectors. This is where we think the data gets more robust, and we add more layers where we look at rank. Here we are reflecting total attorneys in law firms, so solely looking at law firms, and the composition of attorneys in partner versus non-partner. So there was a specific question in the survey that attorneys identified as a partner or non-partner. And here what we see is for the non-partner, the demographic is more diverse than the partner. And what's valuable about this is that as we track this over next several years, we can see how this fluctuates over time. So this is what we refer to as the intersectional analysis, where we look at several dimensions related to satisfaction. So in the survey, we asked attorneys to say whether they were satisfied or not satisfied with different aspects of their work experience. There were over, I believe, 10 dimensions in which we asked regarding salary. We also asked regarding performance evaluation, advancement opportunities. So we're just looking at 2 today. And so with respect to performance evaluation, what you see on your right are women versus men. And within each group, within women, we have the breakdown for race ethnicity. So some quick takeaways is that you see male attorneys are much more satisfied with performance evaluations than women. And that would, and you can see that also with the black box, which represents total 43% of men are satisfied with their performance evaluations compared to 37% of women. If we were to look then within women solely, you would see that, again, white attorneys are more satisfied with their performance evaluations compared to Latinos, Asian, Black, and other, and Black having a lower rating for satisfaction for performance evaluations. For women, it's slightly different. Again, white women identifying a higher level of satisfaction for performance evaluation. Latina or Latinx women identify themselves as having identifying the highest rate of satisfaction for performance evaluations, and then Asian, Black, and other having a lower rates of satisfaction. And then for salaries, similar, we're looking at women and men, and then looking within those groups broken down by race ethnicity. So for total, you see for men, there's a higher percentage of satisfaction for salary compared to women at a 39% satisfaction rate for men and 33% satisfaction for women. Looking within men across different racial ethnic groups, white men having a higher satisfaction rate for salary compared to their colleagues in identifying as Latino, Asian, Black, and other. Black also Black attorneys standing out as having a lower level of satisfaction for salary. The narrative is slightly different for women, where the Latina women actually indicate a higher level of satisfaction for salary compared to white attorneys, and then Latino, Asian, Black, and in this specific group, you see that Asian women having the lower level of satisfaction for their salary. So we provided you with just a snapshot of the type of analysis that we can do or are looking forward to doing, and what we're currently in the process in rolling out is an updated version of the attorney census. We had a really robust conversation in our 2019 Diversity Summit, where we had participants look at data that we were able to generate from the survey and received feedback from those conversations. We also identified volunteers not only to the Diversity Summit group, Summit participants, but also other attorneys that work in government, nonprofit, academia, who provided input on type of questions that should be added and what can be done with the data. We also are working with Dr. Aaron Reeves, who has over 20 years of experience looking at diversity and inclusion and advancing those initiatives in the legal profession. And we hope to roll out this next phase of the census as part of the 2019-2020 fee payment cycle.
There, but I think it was in Lisa's slide, we have, as part of our strategic plan, the issuance of our first report card on the diversity in the profession in January of this year. And we've had a number of conversations about what we might include in that. Some of the most provocative things we could include would be comparing large law firms against one another. We have the data to enable us to do that, but we can certainly do comparisons by sector, comparisons within the law firm environment by firm size. The goal is to start making the data public and digestible. If we report on this every year, we can see obviously what our progress is over time. Also next year, instead of just having one diversity summit, we are talking about having multiple summits that are sector specific. The last one we had was really successful, very focused on the law firm setting and what are issues that drive the opportunities for career advancement in that setting. Those issues may not be applicable to nonprofit or government environments, and so I think we're going to have 4 summits next year by sector, really looking at advancement within the professions, within the profession, within those specific sectors. Any comments, those of you that were at a summit or have seen this data before? Nope.
This is Debbie. So I was curious at the slides back where you're showing the women and their satisfaction with their jobs, that intersectional you talked about. I'm curious as to how that breaks. Do you dive in deeper? So the Asian women have the lowest satisfaction, and so what drives that? Do we have what the story is behind the numbers on some of that?
Series of analysis that we're doing where we're trying to understand within these different demographic groups what are some of the underlying factors or experiences they're having that are connected in any way to their satisfaction level. So I think one thing that we're understanding is there are a series of experiences that they are reporting on. So I think our next step is really understanding, is there any correlation, or to what extent there is a trend on what their experiences are. Also looking at rank, because it could be a matter of, is this person in a higher level position or a lower level position, and then how long have they been practicing? So I think there's other components that that we're starting to look into.
Okay, thank you.
So one last point that we wanted to highlight is that for the 2020 attorney census, the key areas that would be added will be a new demographic point, the veteran status, and then the feedback that we received from participants included wanting to add practice area, allowing attorneys to really detail their rank according to their sector, provide information regarding their supervisory experience, and allowing to distinguish between non-equity partners and equity partners, as well as understanding length of time within their current position and seeing how that connects in any way across these different factors, and then lastly, their salary. And we're hoping that this is the census that will continue in future iterations so we can really provide that robust longitudinal analysis.
So I'm just looking at the bill, that AB 3249, and it says about state bar is supposed to develop a strategic plan, set certain goals. Have you done that?
Yeah, we submitted the plan in March of last year, I believe, and then it's a requirement to do it every 2 years thereafter. So there'll be one due March of 2020. And then our strategic plan outlines a goal. So the long-term goal is to have an attorney population that reflects the diversity of the state population. From one of the earlier slides, you see how challenging that is going to be, especially for Latinos who are severely underrepresented in the profession right now. And so there are more incremental goals, like having the attorney population even reflect the law school population because it's less diverse than that. So our strategic plan does outline a number of sort of incremental initiatives associated with the broader long-term goal. Yes.
Any other questions? Debbie?
I just want to make a comment. I always enjoy the presentations that you give because you really highlight some things that it's like, oh, I had no idea. So I really appreciate how you present your research, and I just really think this research is so valuable. So thank you.
Well, that was a terrific presentation. I want to thank you very much, and I also want to thank you for all the work you're doing, not just in the presentation, but in this area. And I also want to thank our member Hailan Chen for all the work that she's done as the liaison to this area and arranging the consultant that was at the 2019 Diversity Summit, which was great. And thank Leah for her leadership in this area as well. So thank you.
Thank you.
Now, we will reconvene at 12:30 for the board meeting.
You did a good job on timing these things.
Did you get enough time?
Right, that's a half hour. That's a half hour to pick up on the other end.
Time? Yeah. John, can we break and chat
Oh,
for
sure.
a few minutes?
Do you want these? Here. I don't think he took his second copy. Thank you.
for that
So
feedback. I
good.
really
Oh.
appreciate it.
Two. I think we might be able to go into open a little bit earlier than that. So for those who are rejoining us at the end of closed, please check in starting at about 1:40. 1:30. 1:30. Okay? All right, we're now in closed.
Okay. All right, this is the resumption of the open session of the.
Turn your mic on.
Great.
Everyone's starting to run them now.
All right, for those of you who didn't hear me, this is the resumption of the open session of the Board of Trustees meeting of today, November 14th. We are running late. We had a number of issues to cover in our closed session. I do apologize for those of you who have been waiting for the resumption of this session. And we will try to move the agenda along briskly, but with enough time to handle the issues that we have. The first item on the agenda is a call for public comment. Is there anyone here in the room who would like to make a public comment? Yes, sir. Oh, I'm sorry, roll call first, yes.
Broughton?
Here.
Chen? Here. De La Cruz?
Here.
Dellen? Here. Duran?
Here.
Iglesias?
Here.
Manning? Here. Kurtula?
Here.
Selig?
Here.
Stallings?
Okay. Public comment. Sir, you had a... Yes, sir. Okay. Please come up, use the microphone since we are transmitting, and please limit your comments to about 3 minutes, since we need, I think we have others who may want to speak as well. Okay.
Thank you, sir.
And please also identify yourself when you're on the mic.
Good afternoon. Thank you. Good afternoon. My name is Julian Sarkar. I'm an attorney here in San Francisco. Although I do represent a number of attorney applicants, including some applicants who are presently engaged in litigation against the State Bar, my communications here today are authorized under Rules of Professional Conduct, Rule 4.2C. On July 29th, this board published a video addressing the premature release of the bar exam subjects on the impending tests, and in that video stated that this board was committed to transparency. About 2 weeks later, on August 16th, this board held a meeting that was closed to the public for a discussion regarding the administration and the grading of the July 2019 bar exam. And this board met again in closed session for that purpose on September 19th, and I believe again today, immediately before this session. And that's in large part why I'm here today instead of at a hearing for the Committee of Bar Examiners. It's my understanding that the Board of Trustees is now taking direct control over this process. And I also, while you're advised to seek the advice of counsel on this matter, the Bagley-Keene Act, it does have a provision for closed sessions to prepare, approve, grade, or administer examinations. However, the board is reminded that the California Constitution provides that a statute shall be narrowly construed if it limits the right of access, and that the elimination of secrecy in our government is paramount. So this board is respectfully requested to disclose this involvement, this direct involvement in the administration and grading of the bar exam in its reports on the exam to the Supreme Court, to our legislature, and to the public. That includes the reports that are required by the California Rules of Court, the ones required by the Business and Professions Code, and by the State Bar Rules. Some of those statutory provisions are pretty vague as to what the State Bar has to include in those reports. So I think that the drafters must have assumed that the State Bar would just include all of the material information that shows the justification for the bar exam. So I'm here to request respectfully that the State Bar provide our Supreme Court, our legislature, and the public with all of the material information they need to determine whether or not its administration of the bar exam is justified. In the State Bar's submission to our legislature regarding the bar examination that's dated March 15th, 2018, the submission is accompanied by a few reports. I've identified a few material points from some of those reports that probably should have been included in the cover letter, and I'm requesting respectfully that the State Bar in the future provide this material information in a way that's clear and straightforward in its reports on the bar exam. By the State Bar's own admission in its final report on the 2017 California Bar Exam Standard Setting Study, it lacks a clear definition or measure for public protection. So, in other words, the State Bar does not have a clear way to describe the justification for the bar exam. And then after that, it tried to find a way to quantitatively show that the bar exam was protecting the public and failed to do so. Some of these other reports, which the State Bar is commissioned to have produced, they addressed other questions. So, for example, Dr. Roger Bullis's report that was titled Recent Performance Changes on the California Bar Examination. In summary, that report tries to answer the question, what's wrong with these new exam takers? What's causing them to fail more frequently? And then he omits in the entirety of this report all of the additional exam subjects that the State Bar has incorporated into the exam over the 9-year period that he studies. And I think it should be noted that this would have required him to essentially blame the entity that was paying him to produce the study for causing the decline in the pass rate. Dr. Bullis then concludes, roughly 20% of the change in the July scores and 17% of the change in the bar passage rates could be attributed to the change in the mix of test takers between 2008 and 2016. So I'm here today to request that the State Bar include in its reports on the bar exam in a clear and straightforward manner that it has substantially increased the subject material that's tested on the examination, and to acknowledge this basic inference that you don't need an advanced psychometry degree to make, which is if you require somebody to memorize an increased amount of information within the same constraint of time, that's going to make them more likely to fail the exam, to have to pay the State Bar additional exam fees and retake the exam. Along with that, March 2008.
You're over your 3 minutes now. Could you please wrap up?
The purported purpose of this bar exam is to protect the public. 3 years ago, State Bar took away my friend's will to live, and I haven't seen any reference to him in any of these reports. That's a pretty material fact for our Supreme Court, for the legislature, and for the public to consider the effects in terms of the administration of the bar exam. If the bar exam is causing more harm to the public than it's providing protection, it's clearly not serving that purpose. It's clear from the reports, however, one thing is consistent, that the one effect that it is having consistently for the State Bar is the increased revenues, which as of 2017 have increased to $20 million. So I'm here to request that the State Bar include this other information that's material to understand the bar exam in its reports.
Okay. Thank you very much.
Thank you.
We have another request for public comment from Ms. Graham. Welcome back, Ms. Graham.
Good afternoon. Good afternoon. My name is Bridget Grammy. I'm the director of the Center for Public Interest Law at the University of San Diego Law School. For those of you who are newer to the board, our center is an academic and advocacy center of research at the University of San Diego, and our job is to monitor several major regulatory agencies in California, including the State Bar, and make sure that it's acting in the interest of the public. And so I have a couple of very brief recommendations today for the bar, and then to comment on one item for the agenda later on. The first has to do with closed session, and I know the bar used to have closed session at the end of the meeting, and I would like to request that you to consider to do that again. We all were waiting for quite a long time, and I think it is inconvenient to members of the public who are here to participate. I know the reason was, I think you were having trouble with meeting a quorum, but you had a lot larger board at that point. And now with the 1 day schedule, I would hope that people can commit to the 1 day and that you would consider that. Another thing has to do with the phone lines. We've talked about this before, but in other boards, like the medical board, they have a dedicated operator that will help to control people calling in to make public comment. And I recommend that you look into that, because not everyone can make it to these meetings, and this is a better way for people who are following along on the webcast to be able to make comment. And finally, when it comes to public comment, I would recommend that you would have comment after each agenda item, as opposed to just having one at the beginning. Sometimes it's harder to have meaningful public comment. Today is a shorter agenda, but if I were to make comment now and you were to consider something 4 hours from now, that wouldn't really be a meaningful participation. So I do recommend that you look at that procedure as well. And then finally, I am a member of the ADLS Task Force, and so I wanted to support the recommendation for later that we be given an extension on our report. I think we're asking through March 31st, and it's really important. We've heard, as you'll probably hear later, many comments, and I think it's really important for us to be able to talk with stakeholders more, get a better understanding of what the concerns are. And also, it's really important that we hear from non-lawyers. We've heard from almost all lawyers with respect to our recommendations, and we need some more time to hear from consumers, from people who are actually going to be impacted by the policies that we are recommending. And so it's really important to have some extra time to take that into consideration. Thank you.
Thank you very much. Those are the only two people who signed in as requesting public comment. Is there anyone else in the room who does want to address the board during public comment? All right, is there anyone on the telephone who would like to address the board for public comment?
Yes.
All right, please identify yourself.
Yes, my name is Daniel Everett. I'm a member of the State Bar of California.
All right, Mr. Everett, please proceed, and please limit your remarks to 3 minutes. Thank you.
And I'm sorry, just briefly, this is in regards to anything?
Yes, anything you'd like to address to the board?
Yes, I could not express how disappointed I am with the State Bar of California. I recently wrote an article published in the Daily Journal on October 25th, 2019. It details how the State Bar, in order to get legislative funds, or i.e. a fee increase, hid a very important study. That study, it turns out, shows that black and brown attorneys are subject to discipline at a rate roughly 4 times as their white male counterparts. I think the study should be a level to engender a reaction of extreme, and I do mean extreme, public concern. I do believe that this is in fact a national issue, maybe one where the Department of Justice's Civil Rights Division should come in. The controls used to essentially spin the study in a way that would illustrate that there's nothing untoward going on at the Office of the Chief Trial Counsel are in fact laughable. Any statistician could tell you that those controls are completely inappropriate. I will be writing a follow-up article on this very issue. It appears after a brief phone call with a Ms. Chuang at the Office of the Chief Trial Counsel. I just got off the phone with her. She denied knowledge of this meeting, but told me, in essence, that I was going to be subject to discipline in response to my publishing that article. I assure you I will not be dissuaded from shedding light on this issue. I'm in fact gearing up for another article, and I'm sending the previous article to any media organization or any concerned citizen that I could shake a stick at. It is absolutely appalling that the State Bar would allow this to continue and that I should be subject to retribution because of it. It is leading to a mass exodus of power in the black and brown community. This is the reason, this is essentially the Leviathan in the room. It is part of the reason why black people have been deprived of power in the state of California for years. I'm surprised that the governor would have signed off on such a thing, but I cannot tell you again how disgusted I am. I'll finally say that I had asked for an opposition to the State Bar's power grab, I believe it is 2271, which would allow the State Bar to essentially circumvent conflict of interest concerns. And I think it is very important that I be allowed to submit documentation as to why that is an abomination of an idea, and it allows the State Bar to further disenfranchise communities of color. I will finally add that I had requested a waiver of any suspension due to MCLE or failure to pay State Bar fees, but again, my entreaties, the documents that I sent to be considered by this committee have been cast aside. I have been subject of discrimination because I have been speaking out, and again, I cannot tell you how inappropriate it is for this board to allow that to continue, and I will not be silenced on these issues. At the end of the day, exactly what I have been complaining about for years has been held to be true by the UC Irvine study. Again, black attorneys are being subject to discipline at a rate 4 times as their white male counterparts. There is hardly an explanation that could justify such an action.
All right, thank you very much, Mr. Everett. Is there anyone else on the telephone who would like to address the board? All right, then we will go into our agenda items, and the first agenda item are the approval of the minutes from September 19th and 20th of this year. Does any board member have any comments on the minutes? And I will deem them approved. Chair's report. First of all, I want to extend a welcome to our 2 new board members, both appointees of the governor, Jose Cisneros, who is not here today, and Chris Iglesias, who is here today. Welcome, Chris. Thank you. Nice to have you on board, and we look forward to working with you and appreciate the background that you bring to the board. Appreciate it. We have admission ceremonies coming up in the not-too-distant future, which are really a very fun affair, and this is to the various board members. We have openings in Los Angeles, Riverside, Sacramento, San Diego, and Ventura. And it would be nice if a board member could attend each one of those. So the dates are generally December 5th in Los Angeles, the 3rd, the 5th, the 3rd, the 5th, and so forth. If at the end of the meeting you could see me very briefly and let me know if you can attend any of these, it would be nice. I've done a number of these joyous affairs with people who pass the bar are proud. Often their families are there, wives, children, mothers and fathers. So if you can do it, I think you will enjoy it, and it's certainly a tremendous expression from the board for these new admittees. Length of board meetings. We're trying something, as I said at the previous meeting, we're trying something this time. It's the one-day board meeting where we have committee meetings in the morning and then the general meeting in the afternoon. It's, to my mind, an experiment, and I'm happy that we are experimenting with this because we do value the time of the board members. Each of you are busy. You have either practices or other activities that you're involved in, and I know that it is spending 2 days at the board meetings sometimes can be difficult. So we're trying one day, but we have to balance, on the one hand, respecting your time with allotting enough time to handle the agenda items that we have to deal with thoughtfully and properly. So if we feel as though we are short shrifting a conversation or we're running too late in the day, we may have to change that. Now, the next board meeting where we're meeting together is in January, and that's a 2-day board meeting anyway, because that's the strategic planning meeting. So we wouldn't change anything until March. I think that gives everybody plenty of time. My point is, if you have board members, if you have a feeling that we should go back to a day and a half or longer board meetings, please let me know, because we are evaluating this as we go. I just want to put on the record that we did receive a letter in lieu of a personal appearance from Thomas F. Coleman regarding elder law, essentially, and I will acknowledge that has been sent out to all board members several days ago, so the board members do have that. We also have as an agenda item 30-1, which is the ratification of the appointments of Jose and Chris to their committee assignments and to their liaisons. I hope everyone's had a chance to look at that. Are there any questions on that? If not, the chair will entertain a motion to ratify the appointments that have been made. Ruben move, Juan second. May I substitute the roll call? All right, that motion is passed. Let's see. Okay, Sean, I think you're up.
All right. As many, but not all of the people in the room know, our executive director, Leah Wilson, recently married her now husband, David, and just returned from a wonderful honeymoon. And we're all very happy for you. And we have just gathered a small token of congratulations for you.
Thank you.
And you and David have our best wishes for a long and happy life together.
Thank you.
I want to thank the board members for making this particular gift possible, and Leah, thank you so much for everything you do for the bar and how far you brought us.
Thank you.
We also have a baby present for Brandon Stallings and his wife. As we heard earlier, they welcomed their first child into the world within this past week, and we are sending a small gift to them as well. So congratulations to Brandon. We look forward to seeing him at the next meeting. And that concludes my chair's report. We now have item 40, the executive director's report. Leah.
All right, so I have a pretty lengthy written report attached attached to your agenda item. What I want to say here at this meeting is just how proud I am of the board, of the bar, for the work that you're going to hear about today. The FARCUS report, as we call it, but the analysis of disparities in our discipline system. And what I am most proud about is we weren't forced to do this. It's not because of a statutory directive. It's not in response to a negative audit finding. We initiated this analysis proactively because we want to give true meaning to our mission to increase inclusion and diversity of the legal profession. And what is so important from my perspective is that often when you talk about inclusion and diversity, you talk about training. Training is wonderful, it's a wonderful input. You talk about convenings and conferences and summits as we've had, and those are all really important activities, but they don't advance the ball on accountability. And what we've done here, as you will hear about a little bit later this afternoon, we've provided the board, the bar, and the public with a vehicle to hold us accountable for a really important set of outcomes. Obviously, our system needs to be fair. It needs to apply to everyone equally. And while statistically, as you'll hear from Dr. Farkas, we can explain all of the disparities that we do see, nonetheless, there are important follow-up steps which we need to take and which we'll be discussing. But again, while the results themselves, I think, are not necessarily happy ones, I want to take a moment to recognize what we've done as an organization. As I indicated in the report, to my knowledge, we are the only state bar that has done this work, the only licensing agency that has proactively done an analysis of this type. So I want to recognize that and applaud us for it, while at the same time, we double down on our commitment to doing what we need to do to make sure that ultimately the system works in the same way for everybody, regardless of race, regardless of income, and regardless of their status as a solo or small firm practitioner. So those are my remarks, and look forward to talking about this more with you when the agenda item comes up. Thank you.
All right, the next item is number 50, consent agenda. There are a number of items on the consent agenda. Many of them have to do with entering into contracts for the next bar exam. But there are others as well. Does anyone have any item that they want to remove from the consent agenda? Seeing no indication as such, I will deem the entire consent agenda items approved. That takes us to our reports of the board committees. The board executive committee met today, and no, I'm withdrawing that. Okay, nothing from the board executive committee. Brad, anything from you?
Just a reminder that several of the items that were approved through RAD will be on it, or were on our agenda today and approved.
On the consent agenda?
Yep, that's correct.
Right. Okay, finance. Mark.
Mark Broughton. Sonia and I met John, and is this on? There we go. Sonia and I, John, and some others I think met this past week, discussed 4 specific items. I believe 3 of them are soon to be discussed here on our agenda, one of which I believe is on the consent agenda. So I'm going to let the items themselves be discussed when they come up.
Anyone who's on the line calling in, if you put your phone on mute, please. We're getting your rustling. Thank you. We're still there.
I think it's just important to note that the finance committee meeting was held to go over the agenda items that certainly the board book specifies should be heard by the committee before they come to the board.
Can we mute them out?
Can we mute them?
Because it includes everybody, huh? Nobody can
Okay, again, anyone who's on the telephone, who's listening in, please put your phone on mute. We're picking up some background noise from somebody. Thank you. Josh, anything from audit?
No report. We're getting prepared for the annual financial audit.
Okay, thank you. And Mark, when we get to the finance, items that have come up through finance, typically you'll move the item after discussion. Okay. All right. On to the miscellaneous agenda items. First, number 701, authority to Where am I? Is that right? Yeah. It is 701. Authority to extend retiree health benefits.
All right, so this is an exciting item. This item advances one of the key components of the fee increase request that we submitted to the legislature earlier this year, and that was approved to go into effect January 1, 2020. You all will recall that we asked for the funding necessary to provide an equitable retiree health benefit to non-executive staff for all the rest of our staff, and that was funded. What we're moving forward with today, or asking the board to approve, is the extension of the benefit to our non-executive, non-represented staff, known as our confidential staff. This is a relatively small group of employees at the bar. The extension of the benefit to represented staff, of course, will have to wait until the conclusion of collective bargaining, which is underway at this time. So asking you to approve amendments to our post-retirement welfare benefits plan, and that will enable us to provide a comparable benefit. In addition, we seek to make plan changes to our executive plan, and these changes will be reflected for confidential staff as well, that allow us to recognize prior CalPERS service in the calculation of service credits that make you eligible for receipt of the retiree health benefit. This is an important component of our recruitment and retention efforts with a de minimis cost to the bar. So asking that the board approve the resolutions as written on the screen. I do have one amendment to also authorize the staff to make a slight modification to the plans as needed to reflect a vision benefit as well. Our executive staff do have a vision benefit. We don't currently have that reflected in the attachment that you have in the agenda item, but would like staff authority to make that amendment before we finalize this plan amendment.
Is there any discussion of this agenda item?
Yeah, can I just ask a question? Adding vision, that won't, I assume that's an immaterial cost increase?
Yes, and it was included in our overall modeling, I believe, that was used to support the fee increase request, but this is a very minor cost.
Thank you.
Any other discussion? If you will entertain a motion.
I move
Okay. Broughton?
Second.
Manning. May I substitute the roll? Motion is approved. 702, admissions information management system and budget amendment and contract approval. Is he here? All right, if she's not right outside, we'll move to another item.
Move to the next one.
All right, let's go on to 703, enterprise resource planning system, budget amendment and contract approval. Is this one of the ones that came up through finance as well?
Yes.
Okay. Mr. Mazur, welcome.
Good afternoon. Good afternoon, Steve Mazur, Chief Administrative Officer. Item 703 requests a budget amendment to increase the project budget for the Enterprise Resource Planning System project by $390,000 and further requests contract approval for the associated vendors. As you know, the ERP system manages our core finance, procurement, and HR functions. We are in the process of replacing our old J.D. Edwards system with the new Oracle Fusion Cloud system. The requested budget amendment addresses 3 categories of changes to the project. The first is a schedule change. The original go-live date was going to be December of 2019. We are pushing that to January of 2020 to account for things that have come up during testing phases of the process, and also to allow for additional time for parallel payroll testing, which we've decided needs a little bit more time. Second, there is a scope change. We are adding position-level budgeting to the project. Right now, the scope only includes line item budgeting, which for personnel would mean just a single line item expense for personnel expenses, as opposed to budget tracking for personnel at the individual staff level. This was actually just a scope oversight during the contracting and procurement and contracting process. So we're adding that back into scope where it should have been all along. And finally, there are various additional resources adding to the project related to additional post-go-live support from the integrator to ensure a smooth transition, additional IT project management support, and some additional data migration and validation activities. We're taking this action now to push the schedule and add some of these additional resources based in part on lessons learned from prior projects, including AIMS, which you'll hear about in just a moment, which have shown that sufficient time does need to be spent on the front end for testing and for data migration and validation activities. I will also add that we are in the process right now still of user acceptance testing, and we are about to shortly start another very critical phase of the project, which is parallel payroll testing, which involves running test payroll runs in the new system and comparing them to actual payroll runs in the old system. The results of that testing will directly influence whether or not we can stick to our plan go live. So January is still the planned go live date based on what is presented in the agenda item memo, but I do want to be upfront. There is still extensive testing that needs to happen, and it's getting more critical as we get closer. So there are always potential risks that could come up that may influence the schedule, and they may or may not influence the project budget depending on the nature and cause of those issues that come up.
Okay, Mark or Sonia, anything from the Finance Committee on this topic?
We are supportive of the, I am supportive of the recommendations, and I urge the board to take a look and approve the request.
Thank you. Yes, Josh?
See, real quick question. When I'm also supportive of having gone through some of these. I know how technical and difficult they are, and even with all of the work up front, many times there's additional work that you just can't contemplate at the time. When we budget these in the beginning, do you set aside any kind of contingency in the budget or in the numbers, thinking about where the project may end up?
I mean, generally, for this project in particular, it was scoped out based on what we thought we needed at the time. So there wasn't, I mean, it does include sort of, within that price, there was a bit of built-in, I don't want to call it padding, but the integrator did build in the possibility of we might need a little more time for this and a little more time for that. So some of that was built in, and we have, as we are now closer to go live, there has been some slippage in the schedule or some additional resources that have been absorbed by that sort of additional planning that was kind of baked in all along. There was not, however, sort of just a big pot of money that was sort of set aside as a contingency for other things that might come up.
Okay, thanks. Any other questions or discussion? Entertain a motion from the Finance Committee for...
I'll move the item.
Okay.
Okay.
So
Second.
Mark, moved and someone second. May I substitute the roll? All right. Motion's approved. Item 702, back to 702, Amy.
Sorry.
Good afternoon. So everything is discussed in detail.
Can you use your mic, Amy?
Oh, this camera. Okay. Is this on?
Identify yourself.
Hello. Is it on?
There you
There we
go.
go. All right, so everything's discussed in detail in the agenda item memo. And there's just a few points that I want to summarize. First, this item makes two requests. The request is for a budget amendment to allocate $725,000 for a phase 2 project to stabilize and enhance the admissions information management system. The second part of that request is to approve a contract execution with Slalom, who is the original system implementer to perform this work. So AIMS is a system that manages, as you may be aware, of all the various functions carried out by the Office of Admissions. It's a cloud-based system that's on the Salesforce platform, and it's replaced a very old green screen system based on the AS400 that has been in use for decades. So it launched in February of this year and has led to many improvements in the various admissions processes. However, at this time, now that we've been using the system for several months, staff have identified the need for some additional functionality that was not originally in scope and some technical problems that need to be addressed. Admissions and IT, along with Slalom, have the original system implementer, did a comprehensive assessment and ultimately identified approximately 48 items. And they've been categorized in 3 different areas. Some are related, about 27 to functionality. And that is, for example, one of the functionality issues is related to online signatures for third parties. We'd like to see the online signature as an online signature and not as a text checkbox. It's a functionality that we'd like to now improve. Now, the other items are technical defects. We have approximately 13 of those. They were not identified during user acceptance testing in the original implementation. And part of that is we've now used a system and they've been identified at this point. An example of that is our admissions tickets. This is admittance tickets for the bar exam. We've identified sometimes when there's changes in somebody's test center, a discrepancy between the test center site and the actual address. And that's something that we definitely need to get fixed. And the last category are issues related to migration or the integration of data that went from the legacy system into the AIMS system. An example of one of the problems that we're challenged with now related to data migration is foreign law school graduates were migrated into the system as U.S. graduates. And that's created a problem in our system, obviously. So, as stated in the memo, we have to take a close look at, we've taken a close look at factors that have necessitated a phase 2 in AIMS, and at the lessons that they provide for future implementation of this system. And there are 3 significant factors that have emerged. First, I've already talked a little bit about this, but the migration and validation of mass amounts of data between the legacy system and AIMS was much more difficult than we anticipated. And the second thing is due to the complexity of the data migration from the AS400, user acceptance testing didn't identify the technical issues that are now coming to light. So user acceptance testing in phase 1 was designed in a very siloed fashion where staff individually had to take on the user acceptance process. There was insufficient end-to-end testing with full and finalized data sets. This phase 2 process will allow us to do 2 things based on the fact that we had these challenges in phase 1 with user acceptance testing. There are going to be guidance sessions, so we're going to be working closely with Slalom and the units. And we're also going to be using finalized data sets, which will help us identify issues and use actual data in the approval process. The third thing is that the State Bar has recently created a project management office, the PMO, within IT, and this will help us deploy a dedicated technical project management resource to this project. And we definitely would benefit from that process. In our initial phase 1 process, our program manager had to leave midstream through the project, so I think a dedicated person that will definitely help this next process. So with that, I just will open it up for questions. And again, the request is twofold. It's to allocate the funding and then also to execute a contract with Slalom.
And just because we have a new board member here, I want to clarify, the source of this funding is the admissions fund, which is not in the general fund. It is not, doesn't derive from licensing fees. So when we talk about a fee increase, none of that funding goes here. This is all funding that comes from administration of the bar exam. So I just want to clarify that.
And this is a agenda item that's been reviewed by the Finance Committee. So Mark or Sonia, do you have any comments from the Finance Committee?
No, I would say that this item was heavily discussed in Finance. I know that I had more than one discussion, not only in Finance Committee with others, wondering essentially how this happened. But the bottom line is that the system will not work appropriately, or certainly the way that we need it to work, without making these corrections or changes. And it's necessary, I think, at least to move us away from our antiquated systems into a much better system. I do want to say, and perhaps you can correct me if I'm wrong, that the additional funding would come from the reserves. It wouldn't come out of our budget, so to speak. The reserves are something like, correct me if I'm wrong, roughly $8 million.
Yes.
And we're well above the 17% needed, or at least recommended. So it's not as if we would have to take this money out of our general fund. So I would, without further discussion, move the item.
Sonia, anything to add?
Yes, I just want to thank the committee. I'd like to thank Amy and Eduardo in putting this together. And I think this, now with the changes and updates, that this will provide good resource to our consumers, and it will be more effective and more efficient. So thank you.
Any discussion? Seeing none, the board will entertain a motion from someone on the Finance Committee.
So,
Sonia. Second. Second from Mark. May I substitute the roll? The item is approved. Motion is approved. Okay, 704, fingerprinting update from Ray. Wait.
There's a PowerPoint on the desktop.
Good afternoon. Dag McLeod, Chief Mission Advancement and Accountability here at the bar. This is right.
Yes, it's
right.
right.
Okay.
Yeah.
Chief of Mission Advancement and Accountability here at the bar. Acoustics are strange up here. I'm here with Senior Program Analyst Carolina Almirante, the lead on our implementation of Little Court 9.9.5. Here to give a status update on this project. I think Sarah just advanced it. The Supreme Court issued California Rule of Court 9.9.5 requiring re-fingerprinting of most active attorneys by December 1, 2019. We're about 2 weeks away from that deadline. This rule was issued by the Supreme Court in 2018. I would be remiss if I didn't point out that this has been a multi-divisional project throughout the bar. There are very few parts of the bar that it has not touched. We've relied heavily upon the Office of General Counsel, Attorney Regulation and Consumer Resources, Information and Technology, Office of Chief Trial Counsel, Office of Communications, and the Office of Research and Institutional Accountability, Carolina Almirante being the lead on that project. There are two main components of implementation that we're going to talk about today. The first is the compliance of attorneys, getting about 190,000 active attorneys into compliance with Rule 9.9.5. The other component is the evaluation then of rap sheets that we receive as a result of the re-fingerprinting of attorneys and the transfer of those criminal records where appropriate to the Office of Chief Trial Counsel. I'm going to move in reverse order, partly because we have a recommendation that finishes off the presentation related to the schedule of penalties assessed on attorneys who will not be we will not have proof of their fingerprints by December 1, but who need to be extended into a further time frame. And in every subsequent year, we also expect to have a small residual of attorneys who have become active recently who have not got fingerprint, who need to get put on a different time frame. The first thing that I want to say then in terms of our evaluation of rap sheets and how we're dealing with the rap sheets is that back in November, 2 years ago right now, November of 2017, we came up with an estimate anticipating the influx of these rap sheets, and we came up with an estimate of what we thought might be the number of fingerprints we would be dealing with, the number of rap sheets. We looked at the rates of criminal activity among doctors from the medical board. We looked at more general rates of criminal activity. And what we came up with for our estimates, sir?
I assume that RAP is an acronym for something.
I apologize. A record of arrest and prosecution.
Thank you.
So the rap sheet evaluation is our evaluation of records of arrest and prosecution that we receive from the Department of Justice. And, those rap sheets contain information on arrests, sometimes without any subsequent criminal activity related to that arrest. Sometimes they contain information regarding arrests and charges, at which point they would most often contain information on a disposition of the arrest and a disposition of the charges, either a conviction, a plea, a not guilty verdict. So the rap sheet estimates, this was going to be our main workload driver, and what we anticipated was going to be a big impact on the State Bar. And so in our effort to, I'm going to go up and just manually run this because I've got some animations in this, and we'll try to fix up the clicker in a little bit because the other presentation depends pretty heavily on the clicker. So at the time that we made these estimates, we had a low-end estimate. We developed a range of estimates. We thought that the low end we would be dealing with about 3,500 or so rap sheets. Middle of the range, we were estimating it could be could get into the almost 7,000 rap sheet range, and then at the high end, low 9,000 range. Now, having received many rap sheets from this process, we still have a range of estimates, and I'm going to explain to you why we have a range in just a moment. But the range is the result of the fact that what we have records, criminal history records of attorneys for whom we have absolutely no information in our discipline management system already. We know that those are new records. We know that those are new records that have never been reported to OCTC because we simply have no previous record of that attorney ever having been in the system before. We have almost 2,000 of those records. And that has been our first priority. Those are the ones we've been focusing on getting into the system because we know that we won't be entering duplicate data into the system. We know that we won't be providing additional work for OCTC to deal with that is something that they may have already dealt with because they might have received a report of that previously. We have another slightly more than 2,000 cases, though, where there is an Odyssey record, Odyssey being the case management system of the Office of Chief Trial Counsel. We don't know whether these records are related to the criminal case that we've uncovered through the rap sheet, if there's any information about it already known to OCTC or not. All we know is we have these, which we have no unique identifier that allows us to go in and do really easy sort of like automated matching of cases to say, aha, we already know that this case is in the system. These cases are going to require a lot more work, and they're going to be the next batch of cases that we work on. And then we have another almost 2,000 cases where there is what the Office of Chief Trial Counsel refers to as a C case. These are criminal conviction monitoring cases, which are exactly the kind of cases that we are seeking with the rap sheets. The criminal conviction monitoring cases are cases where a criminal charge or a criminal conviction has been reported already to the Office of Chief Trial Counsel. We strongly suspect that those are already duplicates, but we don't know for sure. So those are going to require some additional work as well. So to recap what I was just talking about in terms of our estimates and where we stand with the entry of data into the system, the good news is that we had 184,694 attorneys who we got no response from DOJ on, which means that there was no record of criminal history. There was no rap sheet involved. So 97 to 98% of the attorneys who got fingerprinted, no criminal history. What remains, though, our first priority are these 1,962 attorneys for whom we have a rap sheet, we have no previous record in Odyssey. So we have entered somewhere around 1,600 of these records, and we expect to complete the data entry on these cases within the next couple of weeks. We strongly suspect that these are duplicates, but we're going to need to review them. What that leaves us is these cases here. These will be our second priority cases. As soon as we're done with the cases where there's no record in Odyssey already, we're going to begin figuring out how best to evaluate these in an efficient way that allows us to distinguish between some record that's in Odyssey already and the information that we've gathered through the criminal history that we've got from the rap sheets. I think that this is the point at which I'm going to turn it over to Carolina.
So Doug recently discussed the different phases or priorities, and the data that we'll talk about just in a minute or so is speaking to that first priority. But before we get there, the process to get the cases into Odyssey involved ORIA working closely with OCTC for guidance on cases that needs to be prioritized. Again, these are rap sheets that we're reviewing and ensuring that they meet the prioritization identified by OCTC, as well as the procedural practices for reviewing them and getting them into Odyssey. With those procedures in place, we came to some clear guidelines in terms of type cases that we would not include or transfer into Odyssey. And that includes no rap sheets with arrest-only information. And this is in reference to the September board item of earlier of this year with not transferring arrest information through the Odyssey case management system. And then there's no rap sheets with charges and convictions of infractions, and then no rap sheets with criminal history that's already known to the bar. And that in itself allows us to be more efficient in the transfer cases to OCTC. So what you see here is the rate of entry of cases within the last few months. And the first thing you will know is there's a big jump in September and October. I think this is the stage in which OCTC and ORIA were able to really finalize and document their procedures and really create efficiencies in our entry. Also, we've hired additional staff. We had a temp support this work. And again, these are cases that were not known to OCTC, so we were able just to put them in through a very systematic and efficient manner. What we find, though, is that with the increase in the caseloads, it also impacted OCTC's caseload. And so they also supported the work by increasing their staff, but additionally also increased their caseload. And I think at the moment, there's still a lot of information that needs to be obtained from the courts, especially with the rate of information that we push through the system. So at this point, we're transitioning to that second part of the conversation that Dag mentioned, which we are looking at compliance to 9.95. Specifically, the compliance rate. So what you see here is the rate of compliance to the rule. And there was a big spike between two periods. One, once the rule became into effect, and then two, really close to our first deadline, which was in April of 2019. This reflects 98% of active attorneys that are in compliance with the rule. So what that means is that these attorneys provided the State Bar proof of fingerprinting and are now successfully enrolled in subsequent arrest notification, which allows us to receive any arrest or criminal record information, which we review and evaluate to consider putting through Odyssey. So what we want to do here is discuss the remaining 2%. So what does that 2% consist of? So first, the group 5 is the clear one to note is that these are individuals who are going to be subject to involuntary active enrollment, as indicated in Rule 2.46, where despite several contacts and emails and notices, he did not provide any proof to the State Bar regarding the re-fingerprinting. And that was approved by the board. The remaining groups are in two parts. We have groups 1, 2, and 3 who were admitted to the bar or are new to active status after June 1st of this year, and as late as November. And we want to make sure they are given sufficient time to come into compliance with the rule. The remaining group, which is group 4, which is actually a bulk of the population, is they did submit proof to the State Bar regarding the fingerprinting, but their status in terms of successfully being enrolled in subsequent arrest notification services is still pending because of a variety of reasons that occur when you're re-fingerprinted. So the purpose of the new penalty schedule is to address groups 1 through 4 and help them get into compliance, full compliance, where not only do they submit proof, but also are successfully enrolled in subsequent notification services. So, and this is the proposed penalty schedule. And again, we are focusing solely on groups 1 and 4, and we're aligning this penalty schedule with the current fee cycle, where there's 2 deadline dates, one in February and one in June, and June being the one where they will be enrolled in involuntary inactive status.
So what we're asking the board to do today is to approve the new penalty schedule, which was on the previous slide and is also, or excuse me, the timeline for the penalty schedule here on this slide, which in the report, the printed report that's posted to the agenda, is in table 2 for the attorneys that Carolina was talking about in groups 1 through 4. Either recently admitted attorneys, they recently admitted, transferred to active status within the last 6 months, or those attorneys who have provided us with proof that they have attempted to submit fingerprints, but for one reason or another have been unable to do so. Any questions?
Sean. Thank you, Dag. So I think this makes perfect sense for next year, but as I was thinking about this, would it make sense to consider going forward when a lawyer is on voluntary inactive status and wishes to switch back to active, that would require the re-fingerprinting, if necessary, for that individual as a condition of coming back to active status, rather than allowing a substantial amount of time to pass after they return to active status? Because we could have a situation where there's a serious crime on record and the person could be practicing for, I don't know, looks like close to a year. If we applied this schedule indefinitely.
I would ask Dina's clarification on this, but I think that an attorney who's on voluntary inactive would be required to submit fingerprints. I don't think that there's an exception there.
Oh, they would?
Yes.
Yeah.
It's not, so this would enroll them in voluntarily inactive for failure to provide the fingerprints, but anybody who changes their status off of active and then tries to come back on has to get re-fingerprinted. Oh.
And that includes also inactive attorneys have to be fingerprinted prior to status.
Then I'm just confused. Why would we have an ongoing issue where we have attorneys switching from any kind of inactive status to active and they haven't been fingerprinted for subsequent arrest notifications?
Because, go ahead.
So you have a small subject of attorneys, and this impacts less than right now we know less than 100 attorneys who were participated in the moral character application process prior to July 2017, which is where the subsequent arrest notification contract with the State Bar and DOJ went into effect. And so you have a small number of attorneys that did not, after passing the moral character, did not meet the full requirements and then were admitted recently. So we have those folks. And then we also have attorneys that were not eligible to practice. They were suspended of some nature, and I don't believe it's part of their reinstatement process to be fingerprinted. It's not a condition. So they will need to be fingerprinted once they become active.
Let me add one other, I think, more important group. So those groups that you're talking about are going to be relatively small. What we also have, though, is that when an attorney goes inactive voluntarily or involuntarily, we're required to report to the Department of Justice that we're no longer interested in that person. That's actually what the form is called. It's called a no longer interested form. So we are required to say we don't want to get criminal activity information on that person anymore because it's not for us to receive that information. So we will be transferring information back to DOJ to tell them don't give us this information. So for them to then come back into the system, we can't simply reactivate their fingerprints. We have to have them re-fingerprinted.
So just a clarifying point on that, for attorneys that are being reinstated, there is a different process which we're trying to work through with respect to what happens to our ability to receive subsequent arrest notifications. If an attorney is disbarred, there is a process in which they would need to go through the moral character application, and so we set up procedures so that admissions would know that they have been fingerprinted, and then will be enrolled in the contract that's in place. So we do have those measures in place, and we will be rolling into implementation of the no longer interested contract with or process with the DOJ. But the question regarding attorneys that are going into involuntary active and then wanting to return to an active status, there is a process in place that does require them to get re-fingerprinted. So what we're trying to address is a very small group of attorneys that we don't know when they're going to essentially become active. And we're also wanting to support those attorneys who did what they could to be in compliance, but due to procedural complications that does occur, we want to make sure that they get to the finish line.
Any other discussion? Questions?
I just want to say that this was a Herculean effort on the part of lots of our staff, and it really went very smoothly. Maybe not internally to you guys, but externally it did. And so I want to acknowledge and recognize you. Also, the impact on OCTC can't be understated, as I've been pressuring the ORIA folks to get temp staff in there and put these cases into Odyssey, and it ends up on Steve and Melanie's doorstep. 2,000 cases entered so far, nearly 2,000 and more to go. So I just want to recognize all the work that's involved and thank all of you.
Okay. May I have a motion to approve the resolution?
Motion to approve.
Juan?
Second.
Sonia? Second. May I substitute the roll call? The motion is approved. Thank you. All right, item 705, report on disparities in the discipline system. Dr. Farkas.
Have we resolved the clicker issue?
I sure hope so. I'm going to see if we can. We're going to mic up Dr. Farkas. Do you prefer the handheld, or would you like the lavalier?
Well, I'd rather have the lavalier if it works.
Can we mic up the good doctor?
Where do I aim that?
Well, that's a good question. You aim it toward the on position for the power. So it's good to go now. And you're set. I want to say what you want to do this year.
Good afternoon. I'm George Farkas. I'm distinguished professor of education and sociology at UC Irvine. You guys going to introduce yourselves, or yeah, you're going to go first, huh?
Yeah, pass me the mic.
Okay.
I'm Dag McLeod, still Chief of Mission Advancement and Accountability, as far as I know, still. Here with a really important and timely item. We've seen editorials in the Daily Journal about this topic and about the report. We heard a call-in from an attorney who was the author of that editorial. This particular project fits very squarely within the State Bar Strategic Plan. Goal 4 indicates that it is part of our mission to eliminate bias and promote an inclusive environment in the legal system and for the public it serves. I think it also needs to be said, though, for those of you who have read the report in its entirety, it's not an easy topic to grapple with. It's not easy partly in that it will require follow-up, and we're going to be coming back to the board, and we're going to be working internally on a number of projects related to the follow-up, both analytic and operational. But it's also not an easy topic analytically. It's analytically complex, and it involves dealing with multiple regression analysis, which some of you may have seen before and have some familiarity with, and others may not have seen before. Typically, I think when you do policy work, what you see at the most complicated level is a cross-tabulation. You might see a 2-by-2 relationship where you see rows and columns, and you're able to see the relationship of one variable to another or a table. A multiple regression analysis takes it to another level and makes it a little more challenging to get into the work. And it makes it difficult then to apply the findings from that to policy work. But what's exciting about this particular report is that it starts with the question, is there disproportionate representation of non-white attorneys in the discipline system? And it starts with the cross-tabulation. It doesn't finish there. And that first cross-tabulation shows that, in fact, there is disproportionate representation of black men, in particular, in the discipline system. But where the multiple regression model comes in is that it allows us to begin looking at the mechanisms of the disproportionate representation. What are the causes of that? And the real value of being able to look at the causes of that and the correlates of that is that that begins to direct our attention to what we need to be doing as our next steps. So when you look at the causal mechanisms, you can see the relationship between case type. What types of complaints appear to be associated with more discipline or appear to be associated with certain types of attorneys, certain groups of attorneys? What types of complaints do we see appearing in different groups? Leah has signaled on a number of occasions that reportable action bank cases, it's a very minor point that's made in the report, but reportable action bank cases appear to be disproportionately concentrated among African American male attorneys. This is an area we're going to need to look into some more. We also want to look at how representation affects outcomes. We're going to need to look at how prior discipline is taken into account in the prosecution of cases by the Office of Chief Trial Counsel. I've spoken to a number of consultants. It's a little challenging to figure out exactly who is going to work with us on this project because we're a bit of a niche. I've spoken to consultants who work in the area of criminal justice reform, people who work with law enforcement on unbiased decision-making processes and how to implement systems that limit the amount of bias in the system. And although the people who I've spoken to are excited about the project, they've also said, yeah, maybe that's not quite my area. So it's going to be a challenge to find a consultant to work with, but this is going to be part of what we're doing in the coming months. And now that I've sort of jumped way ahead to the conclusions of where we're headed with this, let's back up. I'm really excited to introduce Professor George Farkas, his former student, Ron B., from more than 20 years ago at the University of Texas, Dallas, who did a lot of the really heavy lifting on the data work here to make the data available to Dr. Farkas. Dr. Farkas is a distinguished professor in the School of Education at the University of California, Irvine. He's the author of over 120 articles in peer-reviewed journals. And buckle up. This is some exciting stuff here.
Okay, thank you. Can you hear me? Is this working?
Yeah, I think so.
Yeah. Okay. Where I like to work from the slides. There. Is it okay if I stand here? Does that work? Yeah. Okay. So Ron and I have analyzed your internal data for about a year now, and you have the report, and we have tried very hard to make it straightforward and transparent and to the point. We don't have a lot of time to do this now, so I'm going to give you a very abbreviated version trying to hit the high points. I'm thinking that if I do a good job on this, then you'll be comfortable reading the report itself, perhaps. So what we're trying to do is estimate the magnitude and understand the mechanisms of discrepancies by race and gender in the patterns of attorney discipline. Thanks to Ron's ability to manipulate data, we analyzed data for all attorneys admitted to the California Bar between 1990 and 2009. And we had their disciplinary records, which we carried through to 2018. And we focused on... Sorry?
Sorry. Anyone on the phone, can you please put your phone on mute because we can hear you?
We focused on two of the most serious discipline outcomes of probation and disbarment. And for this presentation, we'll just do disbarment. The patterns are really very similar. So what we did is within each gender, we compared the discipline patterns for Asian, Black, and Hispanic attorneys to those for white attorneys. And it is really useful if you can get comfortable with this table, because what you see is that, let's see, do I have this thing working? I should. Well,
point at that machine.
At that machine.
He
Well,
wants to do
never
the-
mind.
He wants to do the laser.
You're looking for the laser?
Yeah.
Oh, I don't know if it's going to show up on that.
I guess not. So what I want you to see is that the top panel is for men and the bottom panel is for women attorneys. And there was a total of 62,091 male attorneys we were analyzing and 54,272 female attorneys. So the raw numbers are on the left-hand side. The percent of the total are on the right-hand side. The rows are the number of complaints that an attorney was subject to. And we learned that the number of complaints is by far the most powerful predictor of getting these disciplines. And so we found that to understand the patterns of how they were coming out, it was very useful to organize things according to the number of complaints. And one of the things you see is that African American male attorneys had 54%, 54% of them had no complaints. So if you don't have a complaint, you can't receive any of these disciplines. 25% had 1 to 4 complaints, 8% had 5 to 9 complaints, 12% had 10 or more complaints, and the columns add to 100% in each case. If, by comparison, you go to the other extreme, you see that for Asian female attorneys, fully 83% had no complaints at all. 15% had 1 to 4, 1% had 5 to 9, 1% had greater than or equal to 10. So those are actually the two extremes for all these groups. And you might expect that any group that had more complaints will, in the end up with more disciplines. And that's a feature of understanding this that's relatively important. If you look at the white males, who we will be comparing the African American and Hispanic males with, then you see that 68% of the white males versus 54% of the black males had no complaints. So already that is likely to produce more negative disciplines for the black attorneys. If you read down that column, then you'll see that when you get to greater than or equal to 10, that 12% of black male attorneys had 10 or more complaints, whereas 4% of white male attorneys had 10 or more complaints. That by itself is going to account for more negative disciplines toward black male attorneys. So we're going to see in a minute how powerful is this variable number of complaints, but we're going to see that it's very powerful indeed. So the number of complaints you have is going to explain a lot about the patterns that we see. So I've just, that slide just summarized what I just said. So now here's kind of the bottom line. Attorneys disbarred or resigned under disbarment proceedings. If you read down the black column, you see that among black male attorneys with 1 to 4 complaints, 1.1% were disbarred. Of those with 5 to 9 complaints, 6.5% were disbarred. Of those with 10 or more complaints, 26.3% were disbarred. And that pattern is the same for every group. If you go down, you go back. If you go down the white column, you see once again that the disbarment rate goes up very dramatically when you get to the people with a lot of complaints. So that is another important feature of understanding these data. Overall, 3.9%, the total is the bottom row here in the top panel. Overall, 3.9% of black male attorneys were disbarred during this period. 1% of white male attorneys were disbarred. So as a simple matter of arithmetic, that difference, which is 2.9 percentage points, is the difference in black and white disbarment rates. And so from this point forward, we're going to try to understand that rate. By contrast, if you look, let's say, at African American females and white females, the rate for African American females, the total rate is 0.9 of a percentage point. And for white females, it's 0.4 of a percentage point. So the difference is 0.5, in other words, half a percentage point. And so what you see in this pattern is there's still higher rates for blacks than whites, but overall, the rates for females are so much lower that any racial differences are compressed, and the really large differences occur for males. And so the report goes into detail on all these things, but in terms of cutting to the main story, we're going to be focusing on the males. And this is kind of what I just said. So if you think about how those tables were set up, you realize that there are two sources for disbarment. One is the number of complaints you got, and the other is the chance of being disbarred depending upon the number of complaints you got. Now, complaints come in over the transom in a way that is not influenced in any way by the bar staff. So if you're going to understand what the bar staff is doing, then you need to somehow remove the effect of this differential number of complaints for these groups so that you're left with the part that's due to what the staff is doing. So that's what we did. We did a statistical simulation in which we gave to the black male attorneys and the other attorneys of color, we gave them the white male distribution of number of complaints. This is pure arithmetic, honestly, that's all it is. So you give them the white male distribution, you apply that to the total number of that group of attorneys there is, and then in each case you multiply that times the actual rate of disbarment for that group with that number of complaints. And so you end up with the rate these, say, black male attorneys would have had if only their complaints distribution was just like that of white males. And so that is summarized in these two figures. On the left-hand side is the actual. So that's what we've already seen. The blue is males, the red is females. The tall blue line on the left is the actual 3.9% disbarment rate for African American males. And the white male rate over here is at 1%. So that's the actual numbers. On the right-hand side is what the numbers would be if we give the African American males the distribution of complaints that the white males had. In other words, if we remove the effect that black males are getting more complaints and more of them are in a category of getting high numbers of complaints. And you see that when you do that, the black male disbarment rate falls from 3.9% to 1.6%. The Hispanic rate falls from about 1.6% to about 0.9%. The white male rate is, of course, unchanged because we're simulating if the others had the white rates. And so you see that under this simulation, the black male rate is 1.6%, the white rate is 1%. So the difference between those is 0.6%. That's what's left over after you've removed the effect of the different number of complaints. So, and in the cases of the other group, everything is even smaller. And as you can see for the females, it's pretty close to all gone. But that's the first part of the analysis. So the summary is that there's still a remaining difference, 1.6% versus 1%, that is unexplained by the number of complaints. But it's less than the actual total because African American attorneys have more complaints. Now we tried to go further and use the characteristics of the attorney and of the charges against them and of the investigation and the proceedings in order to try to understand how those characteristics might be affecting the chance of being disbarred. So in multiple regression, you're really just fitting an equation, an additive line, y equals b0 plus b1x1 plus b2x2. It's really, this can be taught in high school, it's just arithmetic. And when you put x's as predictor variables, then, and you fit that to the data, the resulting coefficients tell you the effect of that given variable. So in this case, when we see model 1, you read these things vertically. Each column is another regression. When you see model 1 and you see for blacks 0.0319, that rounds off to 3.2 percentage point difference between black and white male attorneys in terms of their disbarment rate. Now, in order to do this, you have to restrict attention to those who have at least one complaint, because you're using the characteristics of the complaint to predict the outcome. So this doesn't deal with the fact that there's a different percent of black and white male attorneys who have 0 complaints. But that was dealt with in the other simulation. In this case, we're just looking to see that for those with at least one complaint, who are the ones who were investigated, what predicts that? And the numbers in red are statistically significant. The numbers in black are not, which means that it's the numbers in red that we would conclude are different than 0. And so if a number is in black, mathematically, statistically, it's equivalent to 0. When you read down model 2, you see that we have added the control variables, number of investigations opened, and percent of investigations without counsel. Those were significant, and when we did that, the black-white difference fell to 2.5 percentage points from 3.2 percentage points. In other words, the difference between 3.2 and 2.5 was explained by differences between blacks and whites in these two control variables that we added to the equation. Model 3, we added just the percent of investigations without counsel, and the black-white difference fell to 0.9. In Model 4, we added both of those variables, the number of investigations open, the percent of investigations without counsel, and the black-white difference, in this case, turned black, which means it's no longer statistically significant. And in magnitude, it was down to 0.2 of a percentage point. So most people doing social science would say Model 4 has succeeded in explaining the black-white difference. And the variables that did that were the ones that were in that regression. In Model 5, we added some more variables, characteristics of how big the firm is, solo versus the firm of attorneys 2 to 10 or greater than 11. And we made that black-white difference even smaller, 0.1 of a percentage point. And finally, we added the number of prior disciplines. Now, each time an attorney has a complaint that gets adjudicated, at that point, they have a number of prior disciplines. So if you had a lot of complaints adjudicated, and if some of them resulted in discipline, then it would be kind of automatic that overall you would have had a higher number of prior disciplines. So this variable is really part of the process of, if you have a lot of complaints and the system works through, it's going to, in fact, you're in fact going to be someone who has a high number of prior disciplines across all the investigations. So in some ways, that's less informative because it's just a description of the process. By Model 6, we have fully explained the black-white difference, and in fact, we've got a minus sign, meaning that after adjusting for all this, blacks are actually slightly less likely than whites to be disbarred. But once again, if it's not statistically significant, it's essentially zero. So we treat it as zero. So the lesson of this is that, yes. I guess we're, okay, so what I was just saying is being shown on the next slide, that once we control the number of investigations open and the percent of investigations without counsel, and you read across to the model where those were added, that's where the black-white difference lost statistical significance and fell all the way to 0.2. And in the final model, when we added number of prior disciplines, it went even further beyond zero. So to most social scientists, this would say, we now understand the determinants of that 3.2 rate of black versus white difference in disbarment. It's because blacks and whites differed on these variables. And when you adjust for that, there's no differences remaining. And I already said this. So to summarize, male attorneys have higher probation and disbarment resignation rates than females. Racial discrepancies are higher among males than females. The largest racial differences between black and white male attorneys was for disbarment, because that's what we've been talking about, 3.9 versus 1.0. Statistical simulation to remove the effects of the number of complaints reduces the size of the disparities instead of the 3.2% disbarment to, let's see, get it right, so it went from a 3.9 versus 1.6 to 3.2 versus 1.4. We used regression analysis. We explained the differences using it. While many of the predictors were statistically significant, there are ways to figure out which ones were having the biggest effect. And the ones having the biggest effect were the number of investigations opened, the percent of investigations without counsel, and the number of prior discipline. Those are the main predictors of these differences. If black and white males had the same values on these variables, they would have the same disbarment rates. The study has limitations. We only looked at attorneys who entered between 1990 and 2009. We didn't know areas of practice of the attorneys or other variables. If you wanted to do more work of this sort, one thing to do would be to understand the sources of the greater average number of complaints. And it may well be that it's at least partially or maybe fully explained by black attorneys being more likely to be in solo practice. And another really interesting thing that to me seems very open to policy changes is investigate the role of an attorney not having counsel during an investigation. Thank you.
Thanks, Dr. Farkas.
Thank
Is there
you.
any additional staff report? I did want you to speak briefly, though, to the additional analysis that's in the agenda item regarding firm size. I want to highlight that we did do that because of the anecdotal expressions over the years about State Bar disproportionately disciplining solo practitioners. And so staff did that bit of analysis that's in the agenda item. And so just speak very briefly to what those results show before we go into discussion.
Firm size and type is already part of the regression, so we had all of those information to control for.
I can't hear.
You speak right into it.
So firm size and type is already part of the information that we included in the regression model. But in order to look at firm size and discipline rates independently, we just ran some additional analysis independently from all of the models included in the final report. We had some reservations about taking the data too far, partly because the source of the firm size and type information came from complaining witnesses. Oftentimes we see a case involving multiple complaining witnesses, the information provided to us are not consistent, and sometimes we have information over time that's different. We also don't know to what extent that's the result of the attorney changing employment. So there are some limitations to the reliability of the data. But given the large number of attorneys, we're able to have some early indication about solo practitioners clearly have a higher chance of getting more complaints, and similar to the analysis by race, gender, those with more complaints would eventually lead to a higher chance of getting investigated and then higher chance of discipline. That's consistent when we look at focus on the firm size and type. And the additional information that we need to have better understanding of the impact of firm size and type, we hope to be able to use the different data sources that we're currently collecting from the attorney profile database, and to set it up so that we be able to take a second look, assuming that we have the same kind of a follow-up structure of the data to allow for that kind of analysis. So this is a very limited scope of the analysis, and that will tell us what the additional information that we need to gather, similar to the overall final report, I think the information about practice setting and case type, all of those would shed light on the role of font size and type as well.
Okay. Anything else from the panel?
I have a question.
Questions?
Yeah, I have a question on the complaints that come into the bar about attorneys. Is there any sort of, if it's listed as that you received, say, 10 complaints, have all those complaints been investigated? And so they were thought to be legitimate complaints and not just somebody, sour grapes, if you didn't give me what I wanted, so I'm reporting you to the bar kind of thing, so that they were legitimate complaints and not just, somewhat unhappy, because I do know people will complain if they had an attorney and then the outcome that they were hoping for didn't happen. Not that they had bad representation, just that the case didn't go their way. And so they blame that on the attorney, and so then they'll complain that, it's ineffective representation when it just wasn't a very good case. So are those also lined up in there as part of their complaints that are counted against an attorney?
They're accounted for in the sense that we look at, like Dr. Farkas said, a series of variables that's correlated. The number of prior complaints. It's correlated with the number of cases, complaints moving on to investigation. So we, at one point, look at the role of number of prior complaints. And in different models, we control for not so much just the raw count of the total complaints, but investigations. The difference being, if you look at investigations rather than all of the complaints, supposedly you control for a variety of different complaints that may not lead to anything. So investigation in that sense might be a better indicator about some misconduct underlying or behind those complaints.
But Debbie, I would add, certainly in terms of the follow-up work that I see as being needed, I think we need to better understand, working with OCTC, how prior complaints in and of themselves are taken into account at the intake stage. Complaints that either had been closed previously in intake or had moved to investigation have been closed. Then how is prior discipline itself taken into account? And there needs to be a better understanding of that decision-making process to move a complaint from intake to investigation. We have done some other analyses to look at, is there a differential rate at which complaints move from intake to investigation by race? And so I think that in the report where we talk about next steps, differential rates of complaints, the first item, is there's a lot more work to do to understand. One, why is it? Why do we have a differential rate of complaints? The one area that we've identified as being noticeable is this reportable action area, but we need to take a look at that. And then what are we doing with the complaints? So how are we handling them internally?
Thank you.
So it's kind of a follow-up to Debbie's question. I just want to be sure I understand. So Dr. Farkas, in your analysis, when you have the axis of number of complaints, are those limited in any way? In other words, complaints that go to investigation, or just every single complaint, no matter how resolved?
Well, if you look at the regression that I put up, it actually says number of investigations opened. So at that point, it isn't complaints, it's investigations.
Right, but for example, looking at the memo, I got
the first slide you had, I think that first table is number of complaints. And then in the regression, it moves to number of investigations.
Thank you. That was my question.
And I just think for me, it's a clear next step to figure out that whole set of issues around complaints, which complaints move to investigation, what the differences are there.
When two variables are highly correlated, it doesn't matter which one you use. And my guess is that number of complaints and number of investigations are in fact very highly correlated. But the question you're asking, I believe it's correct that in our initial table, we had complaints, and in the regression, we had investigations.
Right, that was my
And we
question.
didn't put them both in together because they are so highly correlated.
Right, understood. But the first, so model one, I think, was before you did any regressions, and that's just every single complaint regardless.
Right,
of
I mean,
Okay.
maybe Ron can better explain how the complaints are entered into the data, because we had a question over here about whether meaningless complaints are being counted. Can you explain the process of how?
So ultimately, it's the question that Debbie posed with regard to like a complaint that, say, sour grape, somebody didn't like the outcome of their case, attorney certainly didn't engage in misconduct, but they're complaining. My understanding of OCTC's process, and luckily I have some OCTC people behind me who I'm sure will be happy to correct me if I'm wrong, is that the complaints go to a read attorney, and the read attorney makes the first determination as to whether there are any merits within that complaint at all. It's only after the read attorney has determined that there is potentially something within that complaint that could be, I'm not sure if the term that OCTC uses is colorable, a colorable complaint that indicates that there may be something there that would indicate a violation of the rules of professional conduct, that the facts might support that it would then be transferred to investigation. So I think that this is the process issue then that Leah is talking about a little bit in terms of like understanding. So if the attorney, all other things, well, if the attorney has more complaints, they're more likely to be investigated, all other things being equal. So you've got these different variables, but I think what we really want to look at is what is that process of looking at prior complaints, including possibly prior complaints that have no merit? How do those get factored into the decisions to move a case forward to investigation?
Thank you.
Yes, Sean.
So I apologize, I may have missed this, but one of the things that we talked about, some of us have talked about already, is two things. First, the idea that level of discipline is correlated to the number of prior incidents of discipline is by design, as I understand it, because in the disciplinary system, and Steve Rinaldi, please correct me if I'm wrong, the general rule is each successive incident of culpability found results in stricter discipline. So it's sort of progressive. So that just tells us the system is working as it should. But that raises the question of whether, let's just say theoretically, the first instance of discipline for black male attorneys has some bias where they are getting more first incidents of discipline than white male attorneys say. And then once that happens, it's, in my view, it's kind of a snowball, or it's inevitably going to increase the rates of discipline because that's the way the system is designed. So we do still need to figure out, zero in on at least the first instance of discipline, because once the snowball starts rolling, I think we sort of lose sight maybe of causal factors. So that's still an open question that's very important that we have to look into.
Right, that wouldn't be hard for us to do.
Good. Okay. Any other questions for folks or comments?
I wanted to say a couple things. One, we obviously have focused on this black-white male distinction here for ease of presentation and because it's a lot of data, but obviously you have more going on than just black and white male attorneys. So earlier over lunch, you saw these nice bar briefs that we've started to do with the attorney census data. I would like, or will ask staff to do some similar briefs with this data where we can really dig in and show the Latino attorney information, Asian attorney, male and female, and break it out, because I don't want to just ignore all the other populations for which we did the analysis. I wanted to say that. And just to, again, clarify for the board what is in the agenda item, that we will come back in January with sort of next steps. As Doug mentioned, looking to work with a professional, hopefully who's worked with some prosecuting agencies on how to address any kind of implicit bias in decision-making from a prosecutor's office perspective. That's the kind of consultant we're looking for to help us craft next steps.
All right. Well, Dr. Farkas, first of all, thank you very much, not only for all of your work on this, but also a very clear and interesting presentation on some data that you may think is mathematical, but yes.
Thank you.
It was terrific.
Thank you.
And Dag, thank you for your very powerful and clear introduction. And Ron, thank you for all of your work and your answers to the questions as well. All right, we are at the last agenda item.
But no pressure.
But no pressure.
All right, so this agenda item presents really technical modifications to the strategic plan, mostly around the diversity objectives. These were adopted by the board in January. I think we were ambitious on virtually all fronts in terms of the timeline with which we thought we could complete these. So seeking to modify the strategic plan to reflect more realistic timelines. The other strategic plan item that I call out is an access-related objective, and that is an extension of the due date for the ADLS report. I think as Bridget Grammy referenced in her public comment, we have received tons of comment on this that the task force needs to go through, as well as we hope that the task force makes additional efforts to reach out to both attorney and hopefully non-attorney stakeholders to get feedback. So seeking to extend the due date on the ADLS report. So that's the actual action item that's requested of the board to approve adjustments to the strategic plan as outlined in the report. And then we want to have a little bit of discussion about the January planning session.
All right. So first, anybody have any questions or comments on the resolution? Would anyone move the resolution to be approved?
So moved.
Debbie? And second from Heinlein. May I substitute the roll?
Two are out.
Oh, two are out? Yes, you're right. Okay, let's go through the roll then, please.
Broughton, Chen.
Yes.
Cisneros. Dela Cruz.
Yes.
Jelen. Duran.
Yes.
Iglesias.
Yes.
LeBron. Manning.
Yes.
Pertula.
Yes.
Saleg.
Yes.
Motion passes.
Thank you. Please.
Okay, so, and I think, Alan, you may have, we've discussed sort of, and Sean, the planning efforts, so jump in.
Sure.
So for the last few years, we have used the planning session to really build out the access and inclusion portions of our strategic plan. 2018 entirely focused on access, 2019 on diversity. We have a number of objectives related to both in the strategic plan, and we've been marching forward, working through them. As we come to the January planning session, we need to plan what we're going to do at the session. And so I just like to engage the board in some thinking about that. You know, what we've done typically is take one topic, dig in, and develop. Is there a background?
There's somebody talking now.
Someone on the phone, if you could put your phone on mute.
How many ever had a first position? And how many
We can hear you.
never got it?
All right. So we focused on, we've done a deep dive into one topic area and come out with, 10 to 15 new objectives. I don't know if the board would like to do that again. I would suggest that there are two potential areas of focus for the board. One, also in the access realm that we focused on for the last couple of years. Another, moving back to discipline. It's been some time since we have focused on the discipline, the system in as part of our planning effort, and so there are a number of issues we could address as part of that discussion, including the follow-up to the Farkas work, looking at our recidivism rates, our probation reform efforts underway, our need to kind of get serious about restitution. So there are a number of issues we could focus on the discipline side. On the access side, we've talked about the triple LT, limited license technician efforts or programs that are in place in other states. I think we've had some indication from stakeholders that'd like to see us move forward with that here in California. We anticipate that being a recommendation out of ADLS, so we might want to use the planning session to build the board's knowledge base about what these programs look like, all of the issues around licensing non-attorneys to perform legal work. So these are kind of two different ideas if we want to go in a substantive direction. So just kind of open it up to the board. I don't know, Sean and Alan, if you want to add anything.
Covered. Does any, we would appreciate any thoughts that anybody has or any directions that you might think we should go in. Mark? No?
Well, I'm thinking about something that I may or may not be completely different. There are access issues, actually. One of them has to do with a letter that maybe, or communication that some of us got relative to conservatorships and LPS and so forth, and people that don't have attorneys and the training and so forth. And I thought, well, there's a component there of access in a different scenario, a whole different thing that we've been thinking of before. And the other thing that occurred to me today in looking at the statistics is that there's a relationship between those who have attorneys and those who don't in the discipline system. And I thought, is that an access type of an issue as well? So I don't know, my mind tends to, because most of my work in the past few years has been in access, to think about those issues. Although I do agree with Leah that we haven't really taken a look at the discipline portion in some time. I think following up on some of the ideas that were presented to us today is certainly something I'd like to take a look at. For example, what are the types of cases that are going to generate the other kinds of discipline and so forth. So those are just my thoughts, real briefly going in. If I have a chance to ponder it some more and digest it, perhaps we'll come up with some other ideas.
Anyone else? Any thoughts? I was late. Yes.
I would just second the notion that it would be good to take a look at some of these discipline issues, so how they integrate with the changes that we're making and the technology that the bar itself has as well. And it seems like it's a good time to spend a little bit of time on that.
I hear some sentiment for each of the two buckets, if you will. I tend to agree with that. I hope that we can do both. I'm not sure. We have to kind of plan this out. But I do think that there's interest in the triple LT paradigm, and I'll say paradigm because that may include other similar kinds of legal providers. But that was something that came out of the ADLS work that it seems to have received positive reactions, whereas we had more criticism or controversy over a couple of the other areas. So I think that's something that I would like to see move forward, an investigation into that. It turns out that this has been around for about 30 years. The triple LT concept has been looked at by this board a couple of times in the last 30 years. But I don't know that we've had either the focus or the intent or the experience of other jurisdictions to look at it. So I don't think that this is a inappropriate concept to review. beneficial to take a deeper dive into our discipline system in some of the areas that we've already discussed. So if, Leah, if you think it's something that we might be able to do in some kind of companion fashion, perhaps we can do that.
Okay, let us come up with something.
All right.
Stop and we'll try to do it.
Does anybody disagree with that? Everybody fine with that notion? Great. Anything else? All right, I just have a couple of concluding remarks and then we will get out of here. First of all, I think this is the first board meeting I've ever attended where we didn't have a presentation by OCTC. So Melanie, don't get used to this. Just sitting quietly in the back and observing. I'm sure you'll be up again soon. Second, the admission ceremonies information, please stop by. If you have any interest in it at all, I'm going to leave this with Sarah. And there are some slots that could be filled, and please take advantage of it if you can. And I think I had a third, now I don't remember what it is, so let's not wait around trying to see if I can remember it. Does anybody else have anything before we adjourn? All right, thank you much.